Before we get started, just start here. Hello, everyone. You are attending a virtual hearing of the Board of Municipal and Zoning Appeals for Tuesday, April 5th, 2022. And before I get into my normal spiel, I'm going to share my screen for everyone here so that you can see the board's, the BMZA's website. So right now, what we've done is we've changed the look of it. This particular box, you'll note that I've put on Tuesday, April 19th, the BMZA will return to in-person hearings in City Hall in the Board of Estimate Room in 2:15. Our docket today might not be able to be seen on Charm TV, but it is recorded and you will be able to view it in the future because the mayor's State of the City address is today as well. I will be putting information in this box about any changes or restrictions with in-person upcoming hearings. I was just told that yesterday, so I'll be updating this box, that we will need to wear masks in the hearing room. There will not be a virtual component at all. It will be a strictly in-person hearing. Dockets will continue to be posted here under the docket button. You'll note our April 5th docket is here. A tentative April 19th docket is up, which we'll finalize shortly. The actually need to kind of correct this next docket here. We'll make sure that that one is accurate, and we'll go ahead and put that proposal together. So look at this particular box. We also are going to change how to participate in virtual hearings. It will be essentially how to participate in in-person hearings. And as we move forward, if there is ultimately a hybrid option, this button will be updated. Zoning decisions can be found here on this particular button. As we sign them and they become available, there will be a hot link that you can click on to see the resolution. Okay, let's stop sharing my screen now. And we'll get started. So again, welcome. My name is Katie Byrne. I'm the Acting Executive Director of the Board of Municipal and Zoning Appeals, and the people that you see before you, Mr. James Fields, who is the chair of our BMZA. We've got Mr. Otis Freeman, who is a board member, Sabrina Turner, also a board member, Bill Cunningham, a board member, and Leland Shelton, a board member. Other faces that you may see appear on your screen include Becky Witt, the board's attorney, Mr. French, who is a planning representative, and Madison Russell, who is an intern working with us this summer. So those are the faces that you will see on your screen. Before turning it over to the chair, I'm going to go a little bit through WebEx functions and how they work. Right now, you do not have the ability to mute or unmute yourself or be seen. When your case is called, I will make you a panelist and I will unmute you so that you can speak, and then you will have an opportunity to turn your camera on and we will be able to see you. If you are a call-in user, what will happen is I will go through the call-in users. You will hear two beeps. After hearing those two beeps, if it is your case that is being called, please speak up right away. If I do not hear anything, I will mute that call-in user and move to the next caller. If you're unable to connect to audio or video, please use the chat feature. If a speaker is inaudible, they will be directed to call back. Please do not use the Q&A feature. I don't have the ability to see both the chat and the Q&A, so please use the chat feature only. There are two ways to testify in support or opposition for a matter. The first is, like I just said, the chat feature. You can put in the chat that you wish to testify for a particular matter. Please identify that matter and identify whether you are in support or opposition. You can also raise your hand. There is a raise your hand function that will let me know you wish to testify on a particular matter. Anyone speaking on a matter before this board is to be considered testifying under oath and is required to speak the whole truth and nothing but the truth. If you have any issues with WebEx, please call our office at 410-396-4301. Please do not email me because I can't read my email and run the WebEx at the same time. Also, if you're having technical difficulties and are unable to participate, please email bmza@baltimorecity.gov if you cannot participate in this hearing at all. All right, so without further ado, I will turn it over to our chair.
Thank you, Ms. Byrne. And welcome everyone to this session of the BMZA. For each case, we will hear it and we will endeavor to issue a ruling at the conclusion of the hearing. Unless for some reason we are required to, or we need additional information, or there would be some other matter that we need to take up before we can begin deliberations on the matter. In any event, you generally should receive your decision within 30 days of today's hearing. You can also preempt that wait time by contacting the BMZA office at 410-396-4301. Again, that's 410-396-4301. But in any event, we request that you not do any work until you receive your decision from the BMZA, and certainly don't do any work within Baltimore City without pulling the proper permits. Our docket will be divided, as it usually is, two dockets. One is a consent docket, and the other is the contested docket. The consent docket are those cases for which the board believes it has sufficient information to approve the appeal. And the process for that matter will be to call the case, hear any reports we might have from the planning department and from staff, and to inquire of the applicants whether they have anything additional they'd like to add to the record. And then we will dispose of that case, which effectively is an approval of that application. On the contested docket, we'll do the same thing, call the cases, hear any reports, and then we'll proceed with testimony. And the order of that testimony will be the applicant and then the opposition. And just like in court, the applicant will have the final say in a rebuttal. I do know that we have several matters here for which I believe there's plenty of support and plenty of opposition, but we encourage you to refrain from repeating any basis for your support or opposition that has already been stated. We certainly want to take into account and appreciate what you all have to offer, but we don't, it bogs down the docket to have redundant testimony, simply repeat what support or opposition is already stated. So we need the bases for that support and the opposition. If you hear that, we'd ask you to refrain from simply reiterating that when it comes time for your turn to speak. And with that, we do have a couple of postponements and or withdrawals. So let me just identify those, because if you're here for any of these matters, those matters will not be heard today. The first case that is being postponed or has been postponed is case number 2021-230, 501 through 503 South Broadway. The appellant is Nate Prettle. But that matter is postponed today and will not be heard. Again, 501 through 503 South Broadway, case number 2021-230. Another matter which will not be heard, this matter has been withdrawn and presently is not scheduled to be reset. Case number 2021-354, 1127 North Caroline Street. William Brodus is the appellant. Again, 1127 North Caroline Street, if you're here for that matter, that has been withdrawn and will not be heard. And finally, another postponement is case number 2022-102, 407 South Broadway. Murab Mohammed is the appellant. Again, 407 South Broadway, that case will not go forward today. And now we will commence with our consent docket. And we'll start by calling case number 2022-111, 3430 Round Road. Whitney Gishel is the appellant. And this matter addresses variances to bulk regulations related to the construction of a one-story sunroom and deck in the rear. And I'll hear any reports we may have from planning and staff.
With, for this
Okay,
project.
got unmuted.
Okay, go ahead, Mr. French.
Sorry, it took a moment to get this thing to unmute.
No worries.
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Thanks, sir.
The proposed project is to construct a one-story rear addition sunroom and deck addition. Maximum lot coverage is 45% is required, 53% is proposed, so it's an 8% variance requested. And minimum rear yard setbacks, 25 feet is required, 18 is proposed, so it's a 7-foot variance requested. Let's see, I do not see Miss Herschel here. Let me see if I have something in the chat. No, actually, Mr. Holland, I'm gonna unmute you. Mr. Holland, are you here for this matter too, or only for the other one?
No, ma'am, just for the other one.
Okay, thank you. All right, so we're gonna go through the call-in users. If you are here for 2022-111 3430 Round Road, either please put something in the chat for me, or raise your hand. In the meantime, I'm gonna go through the call-in users. Again, if you are here for 2022-111 3430 Round Road, please speak up when you hear two beeps. All right, next caller.
No.
Next caller. All right, next caller. All right, next caller. Next caller. Next caller. Oh, here we go. I've got somebody here. Kathy. All right, Kathy coming in. All right. So Kathy, I've just made you a panelist. I believe you're here for this particular property. Let me see. Let me unmute you. There you go. Ms. Arches?
Yes,
Okay, excellent.
Ma'am, you're here for 3430 Round Road.
yes, I am. I spoke to the homeowner a few minutes ago and she said she would be on as well.
What's her name?
Diane Morgan Johnson.
Okay, well, I didn't get all the way through the call-in users. I had two left when you popped up, but either way,
Okay.
we can just proceed with you.
Okay.
Ma'am, is there anything you'd like to add to your application at this time?
No, I'm actually representing the company.
Okay,
There are several other structures in the area that were that are similar. So the homeowner didn't think it would be an issue. There's several deck structures and sunrooms in the area.
all right, and you're here to vouch for that?
Yes.
Okay.
And also answer any questions you might have of me as well.
Okay, well, we have no questions based on the material that's before us because you're on the consent docket. And
Okay.
my only inquiry is to determine whether or not there's anything additionally you'd like to add to the record before we rule on the application.
No.
Okay. Katie, do we need to hear from Ms. Johnson? I mean, we've got a representative here. All right, fine. The board, having heard the appeal, we believe we have sufficient information to approve this appeal.
Very good. Thank you.
Thank you so much. Ms. Arches, if you wouldn't mind holding on.
Okay.
Do you work with Ms. Gishel at all or no?
No, I do not.
Okay. I was going to ask you to stay on because there's another matter for which we have Ms. Gishel as the appellant. So if there was connection, I would ask you to stay on.
Well,
But,
Mr. Holland is here for the other one that Ms.
Okay,
Gishel
very
was an
well.
applicant on.
okay. Thank you so much. Great. That'll take care of 2022-111. Move on to 2022-112, 3223 Elliott Street. David Polonsky is the appellant. And this matter addresses variances to bulk regulations related to the construction of a new third floor addition, doghouse, and rooftop deck. Now hearing reports from planning and staff.
Planning Department has reviewed this application and has no comment. Thank you.
Thanks, sir.
The project is to construct a new third floor, again, addition and doghouse rooftop deck. The maximum building height is 43 feet. Anything higher than 35 feet requires, it says this funky little thing in the code, and it's called a conditional use height. So because the property is on a particular street of a particular size, the standard of review for granting essentially what is a height variance would be the same for a conditional use, for whatever that means. So essentially it's 35 feet is what the maximum height is. They're seeking 43 feet for the maximum height. Minimum rear yard setback is 20 feet is required, 0 is proposed, so it's a full 20-foot variance. So it's a variance to a rear yard setback, and it's a conditional use standard for essentially what is a height variance for to go from 35 feet to 43 feet. So I'll get Mr. Polanski. See, I've got David Polanski on here. I don't see Mr. Polanski on the on our list. So I'm going to go through call-in users. Again, if you are here on the internet for 2022-112 3223 Elliott Street, please put something in the chat real quick and I'll elevate you. If not, we're going to go through call-in users. First call-in user. Let's see. I just got a chat that this one might be withdrawn. Hold on one second. No, I didn't see that. All right, we're just gonna go through the call-in users. If we don't see the call-in users, I'm gonna I'll double check the main email to see if this one was withdrawn. All right, next call-in user. Next call-in user. Next caller. Next caller. Oh, looks like there's someone with their hand up. Hold on. All right, there we go. Miss Heath. Miss Heath, are you here for this matter?
No, no, ma'am.
Oh, okay. All right. Next caller. And last caller. Okay, so I've got nothing in the chat. I've got no hands up. So it's quite possible that this one's been withdrawn. I will do a little research, but either way, if we can move this to the end of the consent, and I'll do a little more research to see if I can find this one,
Very well.
if it's been withdrawn.
All right. We'll move on. Case number 2022-113, 3811 Bancroft Road. Donnie Anchory is the appellant. And this matter addresses a variance to bulk regulations related to the construction of a one-story rear addition, 24 feet by 32 feet, 11 3/4 inches. And I'll hear from planning and staff.
Planning Department has reviewed this application and has no comment. Thank you.
Again, this is to construct a one-story rear addition. The minimum interior side yard setback, 15 feet is required, 9.5 feet is proposed, 5.5 feet variance is requested. Minimum rear yard setback, 25 feet is required, 15 feet is proposed. There's a 10-foot setback requested. Minimum lot coverage, 35 feet, or 35% is required, 40% is proposed. A 5% variance is requested. I'm gonna make a note here. We're gonna elevate Mr. Anchory in a moment. When we were all reviewing this application and another application, which will be called also on the consent docket, there was a difference of opinion as to what constitutes a non-conforming structure under the code. So the decision that we've made is, until we get clarity from the law department on what is or is not a non-conforming structure, we're going to continue to operate as the board has in the past, and present this on the consent docket until we have additional clarity. All right, so I've got Mr. Anchory. And Mr. Anchory, I made you a panelist. And you're unmuted.
Hi, how are you?
Good afternoon, Mr. Anchory. Sir, is there anything you'd like to add to your application at this time?
Nope, not at this time.
Very well. The board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thanks so much.
Thank you very much.
Calling case number 2022-114, 21 North Milton Avenue. Kirk Douglas is the appellant. And this matter addresses a variance to bulk regulations related to the construction of a two-story rear addition, a third floor addition, and a rooftop deck. Now hear from planning and staff.
Planning Department has reviewed this application and has no comment.
So the variances requested under the application include a maximum lot coverage with 60% is required, 85% is proposed, a 25% variance to lot coverage is requested. Minimum rear yard setback, 20 feet is required, 15 feet is proposed, so a 5-foot variance has been requested. I see Mr. Douglas here. I'm making you a panelist, sir, and you are unmuted.
Good afternoon, Mr. Douglas. Can you hear me? Mr. Douglas?
So Mr. Douglas, we have you elevated and you are unmuted on our end. If you are unable to speak, you can communicate to us via the chat. He says he has nothing to add in the chat.
All right, very well. The board having heard your appeal, we believe we have sufficient information to approve your
Right.
appeal.
Well, Mr. Douglas, hang tight for me one moment. It looks like someone else has also raised their hand. I'm just going to see. Make sure. Let's see, I've got Miss Heath. Oh, nope, we're good. All right, thank you, Mr. Douglas.
All right, I think I finished that. So we are
You did.
2022-114.
You did.
All right. Okay, moving on. Case number 2022-116, 200 through 202 East Preston Street. Mara Kitchen is the appellant, and this is a request to add outdoor dining and catering to the existing restaurant located on the portion known as 1301 North Coward Street. I'll hear from planning and staff.
Thank you. Planning Department has reviewed this application. Notes that this property is in the Mount Vernon Historic District. Proposed use and the additional outdoor dining area are consistent with the requirements of the historic district. However, Planning Department is recommending, obviously, that approval be subject to the condition that exterior changes, including any additions, demolitions, alteration, and signage, are reviewed and approved by the Commission for Historical and Architectural Preservation. In addition, the department recommends approval of this application be subject to meeting the minimum requirements of subsection 14-329 of the zoning code and these conditions. A minimum of 5 feet of the sidewalk must remain clear and unobstructed for pedestrian access or use. The capacity of the outdoor dining area will be not more than 6 tables and 22 patrons. The tables will be limited to those that can accommodate 4 patrons and are to be kept against the wall of the building in accordance with the sidewalk plan provided by the applicant. There will be no outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by waitstaff. Thank you.
Okay, again, this is a variance to have accessory outdoor dining and catering uses to the existing neighborhood commercial. As Mr. French stated, there are several conditions based on the plans that were updated by the appellant. So I won't reread essentially what those particular conditions were that he had. And it is the existing restaurant, which is located at 1301 North Calvert. What I do want to say, I need to find the applicant here. I don't see Miss Kitchen listed, so I'm going to go through our call-in users. If you are here as the applicant for this particular appeal, please raise your hand or put in the chat that you wish to speak. We did not receive the posting verification on this application. So in the event that the board were to grant this application, we would need proof of posting. In order for that. Okay, Emily Lemur is here from the Kitchen Collective. All right, here we go. Emily, I'm coming right now for you. All right. So
Hello.
Emily, Emily, you're unmuted?
Hi, can you hear me?
Yes.
We
Okay.
can, Ms. Lerman. Ms. Lerman, were you able to hear the conditions that were stated by Mr. French?
Yes, I was.
Okay, and is the applicant agreeable to all those conditions?
Yes.
Okay. Is there anything you'd like to add to the application at this time?
No, I was not clear that we were required to do the posting. When we had our liquor board hearing, they came and did the posting, so that's why that's not in there, and I apologize for that.
Okay, well then we have to do this again. If you did not post, we will need to reschedule you.
Okay.
Okay, so the board does not have the authority to grant this hearing. Posting is required for a period of 21 days. You received a letter from us saying what needed to be posted and what needed to be in that particular sign. So what we're gonna have to do is, I don't think we can hear this one until a second time, our second docket in May. So what we'll do is we'll send you an email with the next time we can get you on the docket and get you posted.
Okay, thank you.
Okay. All right, so this one will be postponed.
Okay. 2022-116 formally is postponed. All right. Moving on, case number 2022-117, 4401 Arizona Avenue. Whitney Gishel is the appellant. This matter addresses variance to bulk regulations related to the construction of a 12-foot by 12-foot one-story rear addition. And I'll hear from planning and staff.
Planning Department has reviewed this application and has no comment.
Thank you, Mr. French.
The requested variances are a minimum interior side yard setback, 15 feet is required, 8 feet is proposed, a 7-foot variance is requested. This one again is another possible non-conforming structure. Again, no general consensus, so we're going to continue with the way the board has treated these in the past. So I've got Mr. Holland here for this one. And Mr. Holland, I just made you a panelist and you're unmuted, sir.
Okay, hi, good afternoon. I'm here to represent patio enclosures as well as the homeowner.
All right. Well, Mr. Holland, the only question I have for you, sir, is there anything you'd like to add to the application at this time?
No, sir, I have nothing to add. Thank you for asking.
Very well. The board having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
Well, thank you, and I appreciate y'all's time. You have a great day.
You do the same. Thank you.
James, just before we go on to the rest of the docket, I would like to remind everyone that please do not use the Q&A. Please use the chat to communicate, and that everyone here is an attendee, and that we do not mute or unmute you until your case is called. We call the applicant first, then we call testimony for support second, and then we call opposition third. Okay.
Thank you. Moving on to case number 2022-118, 209 South Chapel. Eden No is the appellant. In this matter, addresses variance to bulk yard regulations related to the construction of a 3-story rear addition, 6 feet by 15 feet. And I'll hear from planning and staff.
Thank you. Planning Department has reviewed this application and has no comment.
Okay, so there are 2 variances requested. A minimum rear yard setback, 20 feet is required, 7 feet is proposed, so it's a 13-foot variance. Maximum lot coverage is 80% is required, 85% is proposed, so it's a 5% variance requested. Ms. No, you are a panelist and I've just unmuted you.
Hello.
Good afternoon, Ms. No. Ma'am, is there anything you'd like to add to your application at this time?
Yes, actually it's the building is 15 feet wide, and so it's actually a 6 feet setback, not 15. Does that make sense?
No.
No.
So
Okay.
it says 6 by 15. So the building itself is 15 feet wide. So the length of the building is 41 total. And so I'm requesting a 6-foot setback because right now the building is 35. So I'm just requesting to go back 6 feet.
So you don't want a 7-foot variance, you want a 6-foot variance.
Yeah, I believe so. The building itself is 35 and the whole lot is only 41. So I think that's only 6.
Mr. French, do you mind jumping in here with me? Is it, would it be less? Would it be more or less then? Right?
Sounds like the amount of the variance is increasing by 1 foot.
1
Instead of
foot.
being 7 feet from the rear lot line, she'd rather have it 6 feet from the rear lot line,
Rear lot line.
if I'm hearing correctly.
So I basically what I'm trying to do is just build on the entire lot, which is the lot is 41 by 15 and the current house is 35 by 15. So I'm just trying to go back 6 feet. Does that make
You want to
sense?
expand the house 6 feet,
Yes.
but the required rear yard setback is 20 feet, but your house already encroaches into that 20 feet.
Yes. So I'm trying to have it so that there is no rear setback because the lot is very short. It's only 41.
She
Well,
wants
it
to go
doesn't-
all the way back to the lot line, all the way. It's like
Yeah.
100% variant or 100%
Yes.
coverage then. I think it's
Yeah.
different from what we had in our application.
Right. So what we had in the application was there was going to be a foot left. And
Oh.
you weren't going to do the full lot coverage.
Oh, that's fine. 1 foot back is fine. No problem.
Well,
That's
fine. Okay, so-
like this is so Miss No,
Yes.
we can only give you
Yes.
what you advertised,
Yes.
what for, and what you put in the application. And as
Yeah.
Becky was saying, what's in the application is not a full all the way to the rear yard setback.
Yes, I understand. That's
Okay.
fine. That's fine.
So you're okay with a 7-foot, a 13-foot variance and a 5% variance to lot coverage.
Yes, ma'am.
Okay.
Okay, having clarified that, the board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
And again, I'm going to make one additional announcement. Please do not use the Q&A, and cases are not called in the order that they appear on the docket, right? We go through consent order cases first, then cases where there is opposition, those cases will be called, and those cases might not be called in the order. So everybody just got to hang on, okay?
All right, we've disposed of case number 2022-118, moving on to 2022-120. 1708 Madison Street. Hathaway Enterprise LLC is the appellant, and this is a request to use the premises as 3 dwelling units, 1 dwelling unit on the first floor, 1 dwelling unit on the second floor, and 1 dwelling unit on the third floor. And I'll hear any reports we have from planning and staff.
Thank you. Planning Department reviewed this application, noted that there are various variances associated with this application. Planning Department also notes with concern that there is a need for proper sanitation when multifamily dwelling units are created or expanded. And in this situation, the department wishes to draw the applicant's attention to the City Code, Article 23, sanitation, and the importance of maintaining the property consistent with the requirements of that particular article. The department therefore recommends approval of this application, subject to the condition that use of the property complies with terms and conditions of the Baltimore City Code, Article 23, sanitation. Thank you.
Okay, so again, it's a multifamily dwelling, 3 dwelling units. Variances requested are minimum lot area variance, 2,750 square feet are required, 2,640 square feet is proposed, so it's 110 square foot variance to lot area requested, and 1 off-street parking space is required, so it is 1 off-street parking space variance being requested. And as let me see if we have who's here for this one. If again, looks like AV Associates provided the application. So, Michael, are you here for this one, or is Al calling in for this one?
We're both here.
Are you? Okay, well then I'll go ahead and make you a panelist. There you go.
No, this is halfway.
Hey,
Can y'all hear us?
We can hear you. We have Mr. Castagnola and Mr. Berry.
Yes.
All right. Well, gentlemen, it's just the one question for you. Is there anything you'd like to add to the application at this time?
Yeah, this is now frozen. Oh, that's frustrating. I can put in the chat that we have nothing further to add. Yeah.
I can hear
We
you.
can hear you. We can hear you.
I'll take that as a no. There's nothing to add.
Are you able to hear us?
Yes, we can. Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thanks so much.
Oh,
All right. I'm going to change their role. There we go.
We good?
Yes.
Okay. Moving on, case number 2022-129, 3100 East Baltimore Street. September Trees LLC is the appellant, and this is a request to use the first floor as a cafe coffee shop. Now hear from planning and staff.
Department of Planning has reviewed this application and recommends approval. Thank you.
Thank you, sir.
All right. So again, it uses the first floor as a restaurant. It's a conditional use neighborhood commercial establishment. Last authorized use for this location was a grocery store. The property of first floor has had first floor commercial use since 1931. We've got multiple letters of support in the file from community, including Friends of Patterson Park, Ms. Haya, Shannon Toback, and others. We also have Mr. Ernest Lee, a local president association who is here also. But it looks like we have, someone has just put in the chat that they wish to testify in opposition. So let me ask this individual, let me just make sure. Hold on. It's like we have other people here. We have two people here who wish to testify in opposition. I think, was this the last case on the consent docket?
Correct. We were going to go back to one for which might have been a no-show, 2022-112.
Yeah, let's go ahead and put that down. Let's put that one as a postponement because Roxana emailed me that she believes that they emailed to withdraw. So we'll go ahead and just take that one off the docket altogether.
Fine. All right. And this will then be our first contested case then.
Okay. All right. So let me see, get the applicant for 3100 East Baltimore Street, September Trees LLC. All right. Got Mr. Lee here. All right. So I've got Mr. Lundberg. All right. So Mr. Lundberg, I've just made you a panelist. And who else is here to speak on behalf of the applicant?
And good afternoon, everybody. This is Patrick Lundberg. Also here is Randall Matthews on behalf of the applicant as well. You might be in there September Trees, Katie.
All right. Yeah, I see Randall Matthews here. But I can't make him a panelist. I'll just unmute him. So Mr. Matthews, you're unmuted, sir.
Okay. Katie, is this our opportunity to speak on the project or introduce it a
Tell us
little?
about your project, sir. Go ahead.
Great. Thank you, guys. And thank you, everybody, for your time today. So the project, as mentioned, is for the ground floor commercial use at 3100 East Baltimore Street. As mentioned, this property has been commercial for a significant amount of time, most recently a grocery at this corner. Mr. Matthews is currently going through the process of getting it permitted and approved to do a cafe at the ground floor as the zoning application holds. As a neighborhood commercial establishment, this fits within the context of the neighborhood, keeps this property commercial per its historic use. We believe that it really fits the criteria of all other neighborhood commercial related criteria for the project. And ultimately it's going to add to the economic vitality of the Baltimore Street corridor and the Patterson Park neighborhood as a whole. Also to note, we've had numerous conversations with the community and the neighborhood association. And we're committed to working with them long-term as Mr. Matthews progresses with his business plan for the property to ultimately create a business in the neighborhood that's going to work to the benefit of everybody.
Thanks so much. Mr. Matthews, anything you'd like to add at this time?
I would like to add, hello everyone. I would just like to add, I'm very excited on the project, and like Pat said, I'm really eager to just help and work with the community, whatever that means. However, I can assist. I fell in love with Baltimore early on in my culinary career, and I'm just excited to be able to get back and to showcase my chef abilities, my talents there in that Baltimore Street corridor.
Very well, thank you, sir. Okay, and who do we have?
All
in
right, so I
opposition?
know we have some testimony here in support. I believe Mr. Lee said he would be here testifying in support. Mr. Lee, are you here in support?
That's a
For-
tricky question. So maybe I think I'm going to just put it this way. I am here as the president of the neighborhood association, and this project has drawn a lot of interest in the neighborhood because the property was vacant for quite a long time, and also it is directly across the street from another food establishment, namely called Pie Time, which is long beloved by the community. And as the president of the neighborhood association, I was unable to get a good sense of the consensus within the community. I know that this hearing, the facts of this hearing has been circulated among the community, including on social media. So I do not know who else is attending, and I do not know whether they will be testifying in support or in opposition. I will let them speak for themselves. I would also suggest that the board, a lot of us, this is our very first BMZA hearing. We do not know exactly how this works, so I beg your indulgence. But it may be helpful if you could educate us a little bit about what is the question before the board and what are the standards for making your determination.
do you want me to take that, James?
Go ahead. Yep.
Okay, so what's before the board is a neighborhood commercial conditional use. So what that means is, and Mr. French, I think, can also help explain a little bit too, and we've got Becky Witt, who's the board's attorney. So a conditional use is something that comes, well, the first is the classification of a neighborhood commercial, right? So it's in a particular building or property that's been used for a commercial purpose before. And under neighborhood commercial, there are various types of uses that can be approved by the board as conditional. Included in that is restaurant. So conditional use is, it's deemed, for lack of a better way to put it, it's deemed approvable by the board. And the only time that the board can deny it is if it would rise to the level of potentially public health and safety, if the impact of this restaurant at this particular location would have an adverse effect over and above a normal restaurant at this location. That makes sense. So it's essentially in the code as something that's deemed approvable, but the board could place conditions on it, such as hours of operation. You heard Mr. French say sanitation plan. Those are always issues of concern with neighborhood commercial restaurant. So the board could do something like that. They could do hours of operation. They could put noise limits, things like that, in order to lessen a potential impact on a neighborhood. Did that make sense to everyone, or do I need to clarify it again?
It made sense to me, but I cannot speak for everybody else who is attending. I guess the only thing I will say in addition for the record is that Mr. Matthews, I don't know if he goes by Mr. Matthews or Chef Matthews, but he has agreed to appear at a community association meeting this Monday, where he will be able to meet with members of the community and take their questions. So, I am not sure in the end if my testimony counts as in support or in opposition. I just wanted to give the board some context for, I think, the comments that you will be hearing later on.
Okay.
All right, thank you. Okay, so Mr. Lee, let me find you here. All right, I'm gonna go ahead and mute you. And it looks like I was looking to see, we've got 3 or 4 people here who wish to testify in opposition. We do have, like as I said, letters that were received from in support of this particular project, and the board, I believe, has all of those in their packet. So at this point, I will go to Katie Miller, I believe, who wishes to testify in opposition. I guess unless Mr. Matthews, if you know of anybody else that's on, or Mr. Lundberg, of anybody else that's on in support, that we would call them next.
Yes, I do.
Okay, who's that?
Kaya, she was a letter of support as well. She's on there.
Okay, I'll go ahead and unmute her now. Ms. Henley?
Yes,
Ms.
I'm
Henley?
here.
Yes, go ahead.
Can you hear me?
Yes.
Go ahead.
So I am just wanted to very briefly speak in support of this cafe. I am a homeowner in this neighborhood, home about 2 blocks away from where it will be located in the 3300 block. And I myself and the neighbors that I know of and am friends with are very excited for this project. I think that it will elevate the food options in this corridor. For a long time, we've been very limited to the options that we have. I do understand that there is some opposition from the restaurant across the street, but based on what you've said and my understanding of the standards, that's just not something that should be considered when it comes to zoning. And I hope that the board grants it because it will really help to revitalize this corridor and everything that's been going on, not just with the pie shop across the street, but also the historic grant that was given to the church 1 block across and over at 3127 East Baltimore Street. There's a lot happening right now. And I think that most of the people who live there are just really excited for all of the development to come. And truly, I think any business owner who would be upset about a new cafe opening there is not really thinking about the neighborhood, but really thinking about themselves. As a homeowner, I'm thrilled, and everyone else that I know is also thrilled about it. And that's all.
Thank you so much, ma'am. Appreciate your input.
Okay. All right. Mr. Matthews, anybody else that you know of on the line?
No, ma'am, that's it.
Okay, before we move on, there was actually a question that came up. They asked to speak more about the type of establishment. Well, you know what? I'll just call this person when the time comes. And again, please do not use the Q&A, only use the chat. So the next person, if we don't have anybody else, then I'm going to go to Miss Katie Miller in opposition. So Miss Miller, you're unmuted.
Hi, thank you so much. I also just want to clarify, in somewhat of a similar boat to Ernest, it's unfortunate that I think I had to pick opposition or support. What I would like the board to potentially consider is delaying making a decision on the matter. I heard from multiple neighbors that the concept was presented to them as a charcuterie restaurant, completely in agreement with the person who just testified about the need for more diverse options in our neighborhood. I would also like to make sure that we can sustain existing businesses because we just don't have that many options. But I've noticed today that it was listed on the BMZA docket as a coffee shop, which is exactly what is already across the street. So there seems to be a real need for some clarification with the community association. I find that the timing of the docket is just really unfortunate and maybe not in the interest of fully transparent democratic processes. The PPNA has a board meeting this week, and the owner also signed up to present to the community association on Monday. So I think that would allow for fuller community input prior to the board making a decision. I just think things are kind of happening out of order, and I want to make sure that all folks in the community have an opportunity to be heard. It might not change the board's decision in the end, but I still feel strongly that the presentation to the community should not come after the board's decision, but rather before. So thank you for your time. I really appreciate it.
Ms. Byrne, let me just throw this out to the applicant, Mr. Matthews. Certainly what the last caller just said is typically how it works in terms of working with the community and getting the input so that you can resolve any potential disputes and sort of reach a compromise if there are any particular issues. Would you like the opportunity to do that, to postpone your matter and have that presentation that you're scheduled to have and then come back to us perhaps on the next docket so that you're more familiar with what the opposition is and more importantly, may have an opportunity to resolve that opposition before coming before the board?
So thank you for your response. I would like to say that myself and Pat, we've done a number of things we spoke with the right amount of people. We spoke with the neighborhood association, which is Ernest. I've had a meeting with him dating back to the 30th, and I presented the concept outside of my control of what the community might say, but we spoke together, we got an understanding. We even drafted a draft MOU. I think the opposition again is based on a.
Okay, well let me just stop you because my question was, I guess, looking for a more succinct answer as to whether or not you preferred a postponement or not. If it's no, we'll continue to get the opposition and then you will have an opportunity to be heard at the end. Okay.
Yeah, no, sir. No postponement.
All right.
Thank you.
We'll keep it moving. Who else do we have in opposition?
All right, so we have, next person is Max Rhyme. All right, Mr. Rhyme, you're unmuted. I'm sorry if I pronounced your name incorrectly.
Hi, thank you so much. Yes, so I own the small cafe across the street, and I met with Mr. Matthews months ago before he purchased 3100 and gave him a tour of my cafe. And then he came to talk to me about his concept the other week and told me it would be a charcuterie bar with evening hours. I have an espresso bar right across the street. We take in maybe $600 on the weekdays. Everybody knows the population density of Patterson Park is canceled out by the park. There's also Sunga's Cafe and Wacky Waffles, two small Black-owned businesses that have opened in Fairmount in the last year. And those businesses are open in the mornings and also serve a cafe menu. So I guess my question is Mr. Matthews' resistance to sign an MOU saying he'd be open 11 to 9 and instead has put the other business plan forward to be open 7 to 4 with an espresso bar that parallels mine. I guess it just raises big questions. I don't know who his investors are. And it's just.
Did we lose you, sir?
Mr. Rhyme? He's still unmuted, but it looks like we might have lost his audio somehow.
Hello?
Oh, there you are.
Now. You went out for a minute.
I'm sorry. Where was I?
You indicated that there's apparently a different business plan that's been put forward, hours of 7 to 4, as opposed to 11 to 9, and seems to mirror perhaps the hours of the other businesses, including yours.
That is correct. And essentially, I think it creates a situation where we're fighting over the same couple $100 in morning coffee. Nobody, the community is not served by that. And I think this corner just gets so much safer if a business is open 11 to 9. And also bringing Mr. Matthews' culinary talents. I mean, he's part of a restaurant group with 10 restaurants. Why aren't they opening dinner service? That's what we need to make this block safer. And they could make so much more money. Instead, they're just going to bankrupt me. It's absurd.
Okay. Anything else, sir?
I mean, they also took out all the drywall in December, unpermitted, and began demolition early. Yeah.
Okay.
Okay, thanks. I'm gonna go move to the next caller. Next one is, looks like Summer Gunter. Miss Gunter, you're unmuted.
Yes, hi, I'm Summer Gunter. I have lived on the unit block of North Elwood, which is just around the corner from the property, for over 17 years. I'm very excited about the prospect of a restaurant on this corner. However, I'm very concerned about the smart development of the neighborhood. I've been here since 2005. I expect that we will have good development, but I do not see the ability to maintain 2 coffee shops on my block, and I would like to see everyone succeed. In order for the property and the restaurant to succeed, it needs to have a unique, novel concept that's not already represented. That's what I thought was coming. That's why I was excited as a neighbor. It hasn't been presented that way. The original business concept was different, but the concept presented to the board, the concept that's presented in the application here today is not what the neighbors were expecting, and it's not what could succeed in that space. So I do recommend that Mr. Matthews postpone, because I've been to these hearings and I know that that's in his best interest, but it's also in our best interest, because as a neighbor, I want him to succeed, but I also want all of the other restaurants to succeed. And Max is a neighbor. He lives here too. So we want everyone to be happy and well fed and well served. And the only way to do that is if everybody has their own spaces. This won't provide that. Thank you.
Okay.
Thank you.
All right, next one is Sarah Weber. And Miss Weber, you're unmuted. Miss Weber? Let me try it again. There we go. Miss Weber? Okay, so it seems that she can't speak, but she had put that seems like similar. Let's see. All right, so Miss Weber is at work. Miss Weber, if there's anything you'd like to say, please put it in the chat. And let me look at the hand raises. And it looks like I have another person, Precious Argana. So I'm going to move to that individual. So Miss Argana, you're unmuted.
Hello.
Oh, I'm sorry. You're here for a different one. All right. Sorry about that. All right. So in the chat, Ms. Weber stated she's supportive of diversity of business in our neighborhood, and she just wants Chef Matthew to clarify the type of establishment he's going to have. And it looks like I think that's all we have for opposition.
Okay, if that's the case, we'll go back to Mr. Matthews, and sir, you can respond to what you've heard in addition to responding to the last question that was posed, which is a request to clarify the type of establishment you intend to present.
Hi, yes, thank you. Can I refer to Pat first as well, just to assist me with the communication for this, and then I can follow up with that.
Certainly.
Okay. Thanks, Randall, and thank you, James. So just to review, and thank you for the opportunity to respond here. So, at a high level, just to kind of get on, just to make it clear and concise, at this time, as a zoning application and as the docket item says, we're just seeking neighborhood commercial approval to use the ground floor as a cafe. The specifics of that commercial use, be it the menu items, the hours, etc., they're not concrete at this time. There's a concept for this business, as Mr. Matthews has presented to the neighborhood, and really has been consistent in his presentation of that concept for the business. However, it is not set in stone by any means. As Mr. Matthews alluded to, we've made the commitment to work with the community long term. We've made this clear in writing multiple times. Mr. Matthews is going to be attending the neighborhood association meeting next week. And again, this is a long-term plan here, right? And we, the commitment is being made to collaborate with the neighborhood and local business owners long term to best develop something that will be in the public interest. Now, all that said, this project meets all of the criteria for a neighborhood commercial, and it does not meet any of the criteria for denial, we believe, as outlined by the Baltimore City Zoning Code. The support provided, we believe, shows that there is public, that this business is within the public interest. And the opposition here is very specific, mainly to one individual business and to other individual preferences about what this business is able to do. So just keeping it in the big picture in terms of what is being asked today of the board and what the criteria is of approval, we're very confident that we meet that approval. And again, we'll reiterate that we've been making efforts over the course of over a month at this point to communicate with the neighborhood, and we've been consistent in the presentation of the plan. And Mr. Matthews, I think, can attest to that as well. So I'll leave it at that and hand it to Mr. Matthews. Thank you, James.
Thank you. Go ahead, Mr. Matthews.
I just want to piggyback on that and just efforts of you stating earlier that you don't want everybody just to repeat the same thing. But so just to keep it short, like you said, just what we're asking for, despite the perception of what might have transpired or the thought of what is actually going there, the true concise business plan was given to the neighborhood association, as well as nothing set in stone as far as hours or menu options. I could say that my menu options, they're just a unique offerings just from my background. And I'm a small business owner as well. I don't have 10 restaurants behind me or anything. You can Google me. I was with the company that I got a lot of highly acclaimed awards with, but this is a sole project, doing it on my own, no investor. So I have a large undertaking as well. I'm a small business owner who's looking to just do great and well for the community. And I think that is what should be presented along with what Pat said.
Okay. Well, thank you, Mr. Matthews. And we will take this matter up at the conclusion of our docket. Thanks, sir.
Thank you.
All right. So we're going to continue with our contested docket, and we'll go to case number 2021-257, 134 South Patterson Park Avenue. James Heiss is the appellant, and this is a request to use the premises as a multifamily dwelling consisting of 4 dwelling units, 3 dwelling units, primary structure, 1 dwelling unit, rear structure, and a variance is required for off-street parking. I'll hear from planning and staff.
Planning Department has no comment on this application.
The board recalls this matter was before its last hearing, and there was a lot of testimony from the community. And just a reminder that this request is to use as a multifamily dwelling consisting of 4 dwelling units. It currently has a 2-unit multifamily dwelling. The only ask before the board is for a variance for 2 off-street parkings. We've got opposition from Butchers Hill, several Butchers Hill neighbors. Let's see, letter from Councilman Cohen's office in opposition. And this was postponed to see if the applicant could reach a compromise with the neighborhood. The land use card research history for this is multifamily use, various numbers of dwelling units over the years: 1944, 8 dwelling units; 1968, 7 dwelling units; 2004, it was reduced from 6 dwelling units to 3 dwelling units; 2009, it was reduced from 3 dwelling units to 2 dwelling units. So I've got Mr. Heiss, I've made him a panelist, And we also have several people here who still wish to speak in opposition. So I'm guessing that an MOU was not reached.
No, on the day after the hearing, I did prepare a proposed agreement and sent it over to the Butchers Hill Community Association. They confirmed receipt. Just last night, I received a message saying that they were unable to accept the agreement, but there was no further discussion beyond that, just a rejection of the agreement.
Okay.
What was the agreement?
This is where I agreed to make 2 of the 4 apartment units vehicle restricted, so that anybody that were to lease 2 apartments would not be permitted to have cars or trucks.
And was that the salient feature of the agreement, sir? Were there any others that you're aware of that were critical?
No, that was the thrust of it, and I didn't even ask for the community association to support my appeal, just to not oppose it in exchange for that agreement. But like I said, I got no feedback and no negotiation.
They didn't give you a reason as to why that was not sufficient.
Correct. There was no reason given.
If the board were to consider approval of your request, would you stand by that proposal that you presented to the opposition or the community association?
I would reluctantly. I proposed it in the interest of bringing them to the table.
Yes, sir.
I'm afraid if they're able to get this kind of relief without having any type of discussion at all, where would that leave future appellants? So, but I would do it reluctantly, Chairman.
Understood. Thank you, sir.
Anyone else here in support, or should we go right into, because we did a full hearing on this the last time, but I can move, if you have no one else to speak, I can move right to the opposition. You do get the last word.
Okay. I didn't realize we were reopening
Well,
this case. I thought we had
Well,
closed.
I mean,
frankly, to bring back any additional information in the period of time between the last hearing and now, if there's anything additional, and you've provided that exchange or non-exchange, and so that's helpful. So we'll go ahead and hear from what the opposition has to say. Similarly, in what's happened since the last time you were here.
Okay.
Thank you.
okay, I'll start with Miss Braun, Beth Braun. See, but again, as the chair stated, this is just new information from the last time that we were here. So, Ms. Braun, you're unmuted.
Thank you. Good afternoon, everyone.
Afternoon.
Per the direction of the board, I met with the neighbors after we received Mr. Heiss's communication, and we recalled the words of Mr. Cunningham, and I'm sorry, that's the right name, right?
Yes, Mr. Cunningham.
Okay. Who earlier 2 weeks ago was talking about the enforceability of an MOU and that it would require a lawyer's assistance. And so the group of neighbors met, we discussed this proposal, and we realized that there was no way really logically for this to be enforced.
No, it can be enforced.
Well, okay, so we appealed to a lawyer. We asked a lawyer how it could be enforced, and we were advised that, I'm happy to read you this letter that we got. Would that be helpful?
Well, I'm gonna jump in here to save everybody a little bit of time. If the board includes the memorandum of understanding in its consent agreement that has a condition that in his lease terms, whoever signs the lease says that they are non-vehicle people, right? Then that becomes a term and a condition of the order. That becomes enforceable by city zoning enforcement. So Mr. Heiss would have to provide a copy of that lease if it was not signed, if that condition was not in there, then he's in violation of the conditional use, and then the conditional use can be revoked. If you enter into a private MOU between the association and Mr. Heiss, and it does not become part of the consent agreement, then it is not the city's obligation to enforce.
Okay, our lawyer said, I would strongly recommend that this offer, in quotes, be rejected as it is essentially an offer of nothing. I'm happy to read you this whole letter, but that is the advice that we were going on. And just from a practical standpoint, how would we know if the tenant that signed the lease not to have a car got one? I mean, is it our job as the neighborhood to follow those tenants around to see if they're parking down the street? From a practical standpoint, I just don't understand how it could be enforced. The lawyer also referenced it could be a violation of the Federal Fair Housing Act.
I'm not aware of a vehicle being a protected class, vehicle ownership.
Let me ask a question. The interest is in preserving parking and not adding to parking density.
Correct.
Is that fair?
Yep.
Well, certainly presently, I guess there's nobody monitoring anyone. Well, assuming there's no agreement that anybody has undertaken to not provide additional vehicles. You just know when you can park and when you can't. And it appears that the applicant, under the circumstances, is seeking to alleviate that issue. I mean, Ms. Byrne has explained how it would be enforced practically through this board and through this action. There's certainly only certain things we're permitted to do, but if the parties agree to the MOU, it does become a matter of record and is subject to city code enforcement.
But from a logical standpoint, I'm sorry, I didn't mean to interrupt, but seriously, how would we all enforce that? If we found out that one of the tenants that wasn't supposed to have a car had a car, bought a car afterwards, got married, his wife had a car, had a family member come stay with him for an extended period of time. I mean, all of those would generate additional burden on the parking situation. Do we go to Mr. Heiss and then he loses the conditional use, so bam, it becomes a one-bedroom house or a one-unit house? I mean, from a practical standpoint, how could that work?
Outside of, contacting the city agency and then, in terms of reversing what has then been done, I have to think about that. Ms. Byrne or Mr. French, any ideas? I understand the concept and I understand why the offer was made to do that. And certainly there's a certain amount of good faith and fair dealing on the part of the applicant in imposing it and agreeing to abide by it. Whether or not the lease requires, had a provision that invalidated the lease and terminated it as a consequence of a violation of that, I don't know. I'm not in the weeds of it.
You can't evict a tenant for non-payment you have to go to extraordinary efforts to evict a tenant for non-payment. Is there really a judge in the city that's going to evict a tenant for owning a car or for marrying somebody that has a car?
Well,
Be a default of the lease.
And leases are contracts, and if the lease is violated and relief is presented under the terms of the lease for that violation, just like anybody else, you go to court and you address that with the court, and you end up with an order that authorizes you to take the action that the parties agreed to.
And
How
then the
much time
burden,
that takes, I can't tell you.
and the burden is then on the neighborhood to report it to Mr. Heiss, to ensure that he is following up. I just don't understand why this isn't a simple matter. One requires a variance to add more parking. He can't add more parking, so he shouldn't get the variance. I just don't understand why this is even a matter that we would have to compromise on. We have sent a petition signed by 60 neighbors. We have testified 2 weeks ago that the neighborhood is stressed. People are anxious. There is crime in our neighborhood. The further we have to walk away, park away from our houses, the worse it is. We have asked you just to please uphold the code.
We understand what's being asked, ma'am. I'm not going to debate you on what that is. We're here to address the appellant's application. There's support and there's opposition, which is yours. So we will resolve the matter. But the code is what it is, and the variance standards are what they are. So, we're well aware of them, and we will apply them.
Great. Thank you.
Okay, so we've got, it looks like 2 other people, and again, we went through a lot of this testimony 2 weeks ago, so anything regarding the new information is what's being asked here. So Ms. Braun, I'm going to mute you, and we're going to move on to Maggie Peterson. Ms. Peterson, you're unmuted.
Yep. Hello. I was trying to get my video on, but I guess I can't. I live on the block. I live at 116 South Patterson Park Avenue. I, like everybody else, has problems with parking, but my question along these lines with what he's proposing, I am also a landlord in the Canton neighborhood. I own an apartment building, and with my real estate license, it is not the car itself is not a protected right. But let's say the only 2 apartments in that building are left are the ones that you don't have a car, and a disabled person comes and wants to rent your apartment, they have to have a car because of their disability. How are we addressing that? There's just a lot of legality there that as a landlord, I don't believe you could enforce properly. And like Beth said, you don't get to go back afterwards and get a slap on the wrist. The damage is done to the neighborhood. The building has added more units. There are plenty of units in the neighborhood. Why do we need more?
Oh, James, you're muted.
Raises a question that the last caller, I guess, subsequent to that proposal by the appellant, indicated receipt of a letter from counsel. If you would like to make that letter a part of the record to be reviewed and considered by the board, I would suggest you submit that letter.
Wait, I don't have a letter.
Now, not you. I'm just
Okay,
making
just
a comment.
making sure.
Yeah,
The
it
last
says,
caller referenced the letter that was provided to Community Association.
Beth says she submitted it. Let me see if we have it in the emails, but.
And while you guys are looking, the other comment I have, and I was not part of the zoning hearing last time, I had a conflict and I'm very upset about that, but there's so many of these being bought up and turned into multi-units, and then parking is always kind of a side thought. It's very important to our neighbors to stop this constant development and taking these potential single family homes to multi-units with no parking. It's one thing if there was a ton of them on the market and we just needed someone to develop it, but that's not the case. There's a waiting list for people that want large single family homes. So this is not something of necessary need in our neighborhood.
We do have the letter. I'm forwarding it now to all the board members so everyone has it, just in case it wasn't in the packet. All right, Ms. Peterson, anything else before I move on to the next caller?
Nope.
Thank you. And the next person we have is Lindsey Graham. And Ms. Graham, you're unmuted.
Hi, thank you, Kathleen, and thank you guys for your time today. We really appreciate it. I'm a neighbor who lives in Patterson Place. We are the sector adjacent to Butcher's Hill. And the impact of, increased population density has really had a significant impact on parking, certainly. But I just also like to add that increasing the density doesn't necessarily mean that we're increasing the amount of affordable housing. These are not folks who generally are taking public transportation. They do have their own vehicles. So I'd really like to, ask the BMZA to please strongly consider continuing to uphold the one-to-one parking to unit requirement. Because it is having a negative impact on our neighborhoods, and it spills over into the surrounding sectors.
Okay, thank you.
I'm sorry, Ms. Graham, I was talking to you, said thank you, and I muted you and was moving on to the next caller, which is Virgil Bartram. Mr. Bartram, I've just unmuted you.
Hello. I attended the last meeting and I don't have anything to add at this point.
Thanks, sir.
Thank you, sir. And it looks like that's it. Let me check the chat real quick. I think that's it for the opposition testimony.
All right, then it's back to you, Mr. Heiss, for a final word or summation.
So just as a recap, this property has historically had a very dense use at 1.8 units, and has never been able to provide parking on site. It's has a property on the front of the lot and on the rear of the lot. If we were to adjust or alter either one of the buildings, it would affect the historical character of not just the property but the neighborhood, and would invalidate a preliminary CHAP credit that's been approved. Also, I think some of these perceptions about parking are a little outdated. I mean, people travel differently now.
Mr. Heiss, I'm sorry, there was one other person that raised their hand. He's just put it in the chat. If you could hang on 1 second.
Sure.
Thank you. Mr. Moore, you're unmuted.
Can you hear me?
Yes.
I'm sorry. Yeah, Jeff. I'm Sharon Moore. I'm Jeff's wife. He had to step out for a minute, but yeah, I'm just. I'm not going to repeat anything that's already been said. It's just that I'm the occupant right next door to 134. I am 136 South Patterson, and we have lived here 6.5 years. Adore this neighborhood. The best thing about this neighborhood is Patterson Park. There are so many events and activities that bring people to this area that just, I mean, last Saturday there was a huge event, kite flying event, and there were people parked in the bus stop because they want to be a part of these events that the park houses. If Mr. Heiss could live in 134 and help monitor the parking situation, I would be for that. But since he's not even around here, and to be able to monitor who has cars and who doesn't, I just don't see it working either. And I have to agree with Beth Braun, so I'm opposed to the 4. I would love to just see the 2, a private home next door to me and one in the back. Thank you.
Thank you.
Looks like there's one other person who has raised his hand, says he has something new to add. This is Trent Waite, and then Mr. Heiss, I apologize, we will get back to you. Mr. Waite, you're unmuted.
Thank you. Yeah, I wanted to raise one point. Mr. Heiss is buying this house, and he knew it was 2 units all along, and is filing for a CHAP credit or trying to get a CHAP credit on it. And he's saying he will not be able to get it if he tears down that building in the back or makes parking back there. Well, that's okay. He can keep that building and keep the original house and just keep it 2 units and still get the CHAP credit. He doesn't need to turn into 4 units and try to, make more profit on the house. So it's not going to stop him from getting a CHAP credit to keep it 2 units. That's all I have to say.
Thank you.
Thank you. Okay, hold on. I think that's it. So Mr. Heights, you're up.
Are we sure?
I think so. I don't see, Becky, check me. I don't see any more hand raises. No one else put anything else in the chat. I think we're good to go.
Go ahead, Mr. Heiss.
So I was, some of the perceptions about parking are, I think, a little bit outdated is where I was wrapping up with. People travel differently now. There's public transportation that's available. There's a bus stop or 2 bus stops within a 3-minute walk of this property. A lot of the tenants that I have at a property nearby, apartment building in the neighborhood, they travel back and forth to Johns Hopkins on scooters or city bus or city bikes, or they walk. And I have tried to address the community's concerns about parking with indicating that I would make either 2 units parking restricted until such time as I could find offsite or parking or create on-site parking. But there was just no dialogue there. So what else I can do at this point, I just don't know. Yeah, that's it. I've given everything I can. So it's up to the board.
James, you're muted.
Any questions of Mr. Heiss for anyone?
No.
Okay.
I just have one quick question. I'm trying to recall what you said last week, or 2 weeks ago. There was formerly there were 2 units in the main building. Why are you converting it to 3 again, or does it have to be 3? I just wanted to get clarification on that.
When I purchased it, there were 5 apartments in the front building, and they just all weren't used. So, and then in the back, when the back building, there was nothing. I would imagine it was used as an apartment, but the front building had been chopped up pretty well, like I said, into 5 units.
Okay.
And these floor plates are huge. I mean, the first and second floor, 1,250 square foot each. Those are as big as my first house. And the top unit is only 500 square feet, but that's a unit I'm going to build out for potential use for me in the future when the wife and I become empty nesters. So.
Very well. Again, thank you, Mr. Heiss, for your presentation.
Okay.
All right. All right, moving on. Case number 2021-315, 1213 Dundalk Avenue. Luis Montes de Oca is the appellant, and this is a request to demo the existing parking pad, demo existing back concrete patio, demo the existing fence all around the perimeter, and install a new concrete into the parking pad 14 feet by 54 feet to install new concrete patio, the back of the house 40 feet by 40 feet. I'll hear from planning and staff.
Thank you. The planning department has no comment on this application.
So we actually heard this one on February 8th, and it was postponed to allow the applicant to meet with the Graceland Park Improvement Association, who had submitted a letter in opposition the morning of the hearing. We haven't gotten an update either from Graceland Park or from the applicant. There's one variance before the board, and it's maximum lot coverage. 35% is required, 58% is proposed. The request is a 23% variance that's required. I've elevated Roxana to a panelist because we need an interpreter for this one. So I'm going to look for the applicant and make him a panelist. All right, so Mr. Quagla, just sit tight for a moment.
Good afternoon.
Oh, hello.
Hi, how are you?
Good.
Sorry, I don't know, do you have somebody speak Spanish or translator?
Yo hablo
Perdón.
español y mi nombre es Roxana, aquí estoy para ayudarles.
Sí, buenas tardes. Sí, el motivo de este caso es que aquella vez en el corte tuvimos que reaplicar, ya lo hice la reaplicación de todo, entonces ellos dijeron que espere para el día de este corte. Entonces, realmente, ¿qué más creo que puedo hacer?
Ok, permítame tantito, por favor. Katie, does the board need to add anything else?
Well, we had opposition the last time and they were supposed to meet with the community association.
Mhm.
I'm gonna ask if there's anybody just to make sure that they're, you know, because it was Graceland Park that sent the letter. So we need to know, I guess if they had a conversation with Graceland Park, right, James?
Yes, if there's, again, what's happened since,
Since February
Since
8th.
last time. Okay. All right, let me ask them. Básicamente lo que queremos saber es si ustedes tuvieran la oportunidad de reunirse con la comunidad, porque por eso se pospuso la audiencia que tuvimos en febrero a esta fecha.
Realmente mandamos una carta al correo que usted me mandó y nunca han respondido. Entonces, realmente no hemos podido recibir ninguna noticia de ellos. Mandé el correo a la persona quien estaba encargado de la community, entonces, pero no recibimos ninguna respuesta en el correo.
Okay, permítame. So, they're saying that they email the community, but they never receive a response.
Okay, we have, just to remind the board, the last time we received a letter from Eddie Schuman and from the Graceland Park Improvement Association. And I do not see Mr. Schuman or, I don't see anyone having their hands raised for, like anyone new having their hands raised for this one in particular. I don't see anything necessarily in the chat, but I'll remind the board what the opposition was. It was from Eddie Schuman, Graceland Park Improvement Association. It said specifically the 40 by 40 proposed patio area does not conform to the neighborhood. This is more of a large courtyard or parking lot rather than a residential patio. There's nothing to say that this patio won't be used for further parking areas. There's way too much concrete proposed. The rest of the neighborhood homes have much smaller patios with grassy landscaped areas to present a neighborhood feel. We do not want to portray a commercial type of look in our community. Also, the parking pad is too long for a single family home. Again, too much concrete portrays a commercial type of feel, which is unacceptable in a traditional residential neighborhood. Therefore, we do not object to this variance. Therefore, we do object to this variance. Thank you for taking time to consider our objection. So I guess at this point, I can go through the call-in users and see if there's anybody here in opposition.
Sure.
Okay, all right, so going through the call-in users, if you are here in opposition for 2021-315-1213 Dundalk, please speak up. Going to the next caller. And 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 this is the last caller. Okay, so that's it. So we have no additional opposition testimony for this one.
Okay. And unless the applicant has anything else, we'll conclude this matter, I guess. Do we need to ask?
So Roxana, can you ask them if they have anything else to add? And that they're telling them there's no opposition on the line?
Sure. No encontramos ninguna oposición en la línea. ¿Hay algo más que ustedes quieran agregar?
No, realmente lo que necesitamos es la aplicación que hicimos el submit, que se apruebe, porque realmente estoy un poco de complicaciones porque el trabajo se paró ahí, entonces me empezó a dañar mucha agua al basement, entonces necesito que el trabajo se concluya.
No, they're
No.
just asking, if the board can grant it because right now they're having water issues with the basement because the work has not been concluded. That's pretty much what she wants to add.
Okay. Thank you.
All right, thanks. Roxanne, if you could just tell them that, thank you, and that the board will make a decision.
Gracias. Entonces la barra va a ser una decisión al final.
Roxanne,
Le
if you could
agradecería.
get her name, please. I don't think I have her name.
Sure. ¿Cuál es su nombre?
Mi nombre es Luis Montes de Oca.
Okay. Becky, it's the applicant,
Okay.
Luis
Okay.
Montes de
Got
Oca.
it. Thank you.
You're
Okay.
welcome.
Okay,
Okay.
gonna move on to case number 2021.
Great. Okay.
All right, moving on to case number 2021-353, 322 South Ann Street.
Oh, you know what? We missed, the 2021 169 630 Harvey Street, which was the first one on the contested docket.
But I thought we were doing that third to last.
Oh, you're right. You're right. Let's see. Yep, you're right. Sorry about that.
All right. So we'll go with 2021-353, 322 South Ann Street. Ryan Rattani is the appellant. And this is request to use premises as a multifamily dwelling consisting of 3 dwelling units. Variance required for off-street parking. I'll hear from planning and staff.
Thank you. Planning Department has reviewed this application. Noted that this property is in a National Register Historic District known as Upper Fells Point. Property is currently authorized for use as 2 dwelling units, and the application proposes to add a 3rd dwelling unit in the basement of the existing building. The issue the Planning Department is concerned about is a basement apartment needs to have 2 means of emergency egress in the event of fire or other emergency. This particular application included a floor plan which shows that there is a basement door at the rear of the property leading to the rear yard, but there is no other indicated means of emergency egress. And the particular building is one that appears, because it is semi-detached, that would require either a use of a portion of the public sidewalk in front of the building or a use of the public alley beside the building. This particular alley is of a width indicated to be roughly 10 feet, and the department is not convinced that the applicant is going to be able to provide out of public right-of-way, which he must obtain a permit for use of, sufficient space to provide emergency egress and at the same time allow the public sidewalk to continue to meet ADA requirements for safe passage of pedestrians, or in the case of the alley, to allow safe passage of vehicles in that alley. The department is recommending disapproval of the application because the amount and proportion of lot area variance needed for approval is excessive in relation to the standards contained in the zoning code, which would be 43%. And the department notes that this use of the property as 2 dwelling units, if it was in fact being considered by the board, would require a 29% area variance. Therefore, the applicant is increasing the amount of variance applicable to the property. And secondly, because the application proposes a variance without providing any justification for the increase in the amount of variance needed.
Thank you, Mr. French.
2 issues before the board. A lot area variance, as Mr. French stated, 1,875 square feet required, 1,065 square feet proposed, so it's an 810 square foot variance. For the additional unit, 1 parking space is required, 1 space variance is requested. The last authorized use of this property was as a multifamily dwelling with 2 units, so this application seeks to add a 3rd unit in the basement of the building. And we have the property owners, Mr. and Mrs. Spartani, you guys are unmuted.
Thank you very much. So actually, I believe Al Berry was going to speak first, and then we're happy to.
Oh, Al,
follow
he's
up
on the
with any
phone. Okay, so sit tight. Let me go through the call-in users. I'll get Mr. Berry.
Thank you.
All right, going to the next caller. So Al, when you hear 2 beeps, please speak up. Next caller. Going to the next caller. Next caller. All right, got 2 more. Next caller.
That's me.
There we go. All right.
Okay.
Welcome, Mr. Berry.
Thank you. Do you want me to start or
Go
do you want me
ahead,
to
sir.
start?
Absolutely. Go ahead.
Okay. And then I want to give a brief presentation why I think the board has the authority and should approve this. And then I want to have Mr. Rattani and his wife give some of their background, how they got into this. As an overview, they purchased the property. It was already 3 dwelling units. I believe you'll hear from them that the previous owner renovated the building, obviously the 3rd unit without a permit, 13 years ago. So there's been a unit in the basement for 13 years before they bought it. Immediately, once you hear his background, you'll recognize why he realized he needed to legitimize this 3rd unit. So the zoning application was put in. And he asked us to help in coming up and trying to convince the board today why he and his wife should be allowed to maintain the 3rd unit. With all due respect to the planning department's recommendation, I'll address 3 issues that came up. The first and most important is the uniqueness standard that one needs to find, or the board needs to find. Yes, this is a small building on a small lot. However, if you look at the 5 or 6 adjacent properties and houses on Ann Street, just to the north, you'll find that the lot size for this house is frankly much smaller, substantially smaller, 32% from the remaining houses on the block. So when one talks about a 29% variance or a 42% variance as what planning, you have to put it in the context of what the average lot size is. These properties are unique for that block because they have a much smaller lot size. They're not as deep as the other buildings. So if you take that into account, we added up the buildings just north, and the average lot size of those is 1825, which is 800 and some, almost 800 square feet more than the client's property. If you averaged out the lot sizes, you would find that the variance being needed is only 14%, going back to planning's rationale. Again, the unit's been there. We think that in the context of the block, it's a unique property and smaller and should be found to have the standard to get the additional unit. More importantly, the unit's been there. The neighborhood has met with the Rattanis. They are fully in support of the zoning board's approval of this. So for 13 years or 14 years, this additional unit hasn't been a burden on them. Otherwise, they wouldn't be supporting. Parking was also mentioned. Mr. Rattani has told me that the other properties along that block all have access to the same 10-foot alley, and many of them have parking. He'll testify to that himself. And then finally, the code issue about emergency egress, Mr. Rattani is well aware of that. We've spoken to him. I believe we sent the board a contract he has with an experienced contractor that has done these types of openings before. There is an opening into the space where the bedroom would be. It just needs to be made wider and taller, larger, to meet the code standard. And we would ask that if the board approves the third unit, which we hope you do, obviously, that be made, obviously, a subject condition of approval. He would add the parking in the back where other properties are using that same alley for access. He would commit to doing he would have to do the occupants, the egress to get an occupancy permit if it gets that far. He didn't want to go ahead and do that before we had the zoning board approval. And with that, unless there are any questions, I'd like to introduce Mr. Rattani, give you a little bit of his background and any more information you might need. Brian?
Great, thanks, Al. And thank you everyone for the opportunity to testify today. So my name is Ryan Rattani. This is my wife, Chelsea. A little bit of background on us. We met while studying urban planning at University of Maryland College Park. Chelsea was the first to take a job up in Baltimore. She works for an international development nonprofit that's headquartered in the city. She's been there for 6 or 7 years at this point. After graduating, I joined the city finance department, which I think is what Al's referring to. And I was part of the fiscal integrity unit where I managed a portfolio of property tax credits ranging from the new construction to the CHAP to high performance and easy credits. I also led the creation of the public safety officer tax credit, which was designed to retain first responders in the city. After that, I joined BDC, Baltimore Development Corporation, where my responsibilities ranged from RFPing surplus city property for redevelopment and more recently, helping businesses apply for pandemic-related funding and relief. And I currently work for Reinvestment Fund, which is a CDFI nonprofit commercial real estate lender, and we lend to affordable housing developments and healthcare clinics and other community facilities in the city. So that's a little bit of the background about us. We are city residents. We live in South Baltimore with Chelsea's mother and our 5-month-old son. This is our only investment property. We have one, and we self-manage it. We go over there about every weekend to make sure that it's maintained. The folks on the block are very mindful of upkeeping their property, and I think that you'll see from us not having any opposition from our adjacent property owners that we do our part to maintain that. And then, so again, as Al mentioned, the property was 3 units when we bought it. We believe there was a history of renting the basement unit, not on the up and up, and we're here to correct that. I want to make sure that we're doing this the right way. We are aware of the egress issue, and I have solicited quotes to remedy that. Obviously, I think if the board can review the quote, you'll see that it is not an insignificant amount of money. It's $15,000 to put the egress window in, and I want to make sure that we are actually going to get this zoning relief before investing that money, I think, for obvious reasons. And then just quickly to touch on the parking, again, the Upper Fells Point Improvement Association unanimously voted to support this zoning relief, and they are fully aware of the parking issues in Upper Fells, so they do not think that's a problem. Our tenants, we have 2 existing tenants now. Neither has a car. They are both young professionals and students at Johns Hopkins. And like another appellant testified to, that cars are not the only mode of transportation nowadays. So I don't think that's going to be an issue. However, we are more than willing to provide parking as a condition of approval by BMZA. There is space in the back. We could also make it a parking restricted unit, as another case discussed earlier on the docket. We are more than willing to work with whatever parameters the board thinks is appropriate. We just want to be able to rent this unit safely and fully legally, and we are more than willing to be flexible and work with whatever recommendations the board has. Thank you very much.
So there's no public opposition. It was just the, what do you call it? Planning. Sorry.
Planning.
And we sent the board a summary of the square footage and all for the adjacent properties that we hope demonstrates the uniqueness and gives the board, we hope, reason to approve it today with the conditions that Mr. Rattani suggested, parking and obviously the egress.
Okay. Very well. Any questions of Mr.
Okay.
Berry? All right. All right.
Anybody?
Nope.
Okay.
I
Thank
think
you
we're
very
good.
much for your time.
Thank you.
Thank you, Mr. Berry.
Thank you all.
Thank you.
Bye-bye.
Right.
All right, so now I think we're back to the,
Back to,
I think we have three left, right?
right.
Yeah, Harvey Street, the other South Ann, and then Bennett Street.
All right, so 2021-169, 630 Harvey Street. James Stewart is the appellant. And the appellant requests to construct a pergola that exceeds height regulations. So I'll hear from planning and staff.
Thank you. Planning Department reviewed this application and has no comment.
Thank you, Mr. French.
Okay, again, the project is to construct a rooftop pergola, which would exceed maximum height restriction for an R8 zone. Maximum height, again, this is that funky conditional use standard for a height variance. It's a maximum height allowed by right is 35 feet. Appellants can request a height variance between 35 and 45 feet as a conditional use. This appellant is requesting a 39-foot height, so essentially he wants to go 4 feet higher than the maximum is by right. So essentially there's a variance request, but a more lenient standard as the conditional use standard is applied. We received 2 letters of opposition yesterday, saying that it would block water views of homes in the neighborhood, unnecessary for Riverside to have an unobstructed view in exchange for an aesthetic improvement to 630 Harvey Street. Water view and classic view of Domino's Sugar Sign are a huge value to our community. Value of our homes will decrease if our rooftop views are obstructed. So I actually do not see James Stewart listed here. So if you are the applicant and you are here for this this particular case, if you would please raise your hand or put in the chat. Otherwise, I'm going to start going through the call-in users. All right, first call-in user. Again, if you are here for 2021-169, 630 Harvey, please speak up. All right, next caller. All right. Next caller. So again, I'm looking for the applicant here for 630 Harvey. And the next caller. Got 2 more callers. And my last caller. All right, well, seems we cannot find the applicant. Becky, help me out here, see if there's a hand raise I'm missing. Wait, let's see, all right, we got Ryan already. Ms. Heath, maybe? Ms. Heath, are you here as the applicant for this?
No, I'm not. I'm
That's
here
right.
for Bennett Place.
That's right. Okay, thank you, Ms. Heath. I knew that. All right, well, in light of, oh, let's see, John, let's see. Mr. Krasinski, Krasinski, are you here for the applicant?
No.
Okay. Ms. Alonzi, are you opposition or applicant?
Hello, I'm here as opposition.
Okay. All right, I'm hitting all the opposition. Still haven't found the applicant though. All right, let me check the chat. All right, so we've got 3 or 4 people in opposition, but I do not have an applicant. So I guess we can do one of 2 things. We can postpone this or we can move this to the end. James, up to you. What would you like to do?
Well, I want to keep the docket moving, so let's move it to the end if we can't find the applicant at this time.
Okay, all right. All right, so those of you who are here in opposition, we're going to try to call this later.
Okay. Moving on to 2021-343, 808 South Ann Street. Caroline Hecker is the appellant. There's a request to use premises for ancillary non-residential use related to the adjacent property at 1724 Ames Street, specifically to use a portion of the rear of the premises as a dining room for the restaurant at 1724 Ames Street, and to use a portion at the front of the premises as office space. We'll hear from planning and staff.
Thank you. Planning Department has reviewed this application. Notes that the property 808 South Ann Street does have a record as use for non-residential purposes, even though it is zoned RA. The particular use was a retail goods establishment with no alcoholic beverage sales, which is a different type of neighborhood commercial establishment. The requirements that the property be used in a way that's pedestrian oriented, the department feels would be met because the traditional commercial uses in this portion of Fells Point are pedestrian oriented due to the historic character layout of Fells Point and of its streets. And with regard to the proposed use of the rear of the property for the dining room would have a direct entrance at 1724 Thames Street, and therefore that property could meet the requirements for neighborhood commercial establishment use by having a direct entrance to a public street. There is no off-street parking required, as the proposed use would be approximately 2,100 square feet of gross floor area, and the threshold for a requirement is 2,500 square feet. This property is in the Fells Point Historic District, and all exterior changes be required to have approval in advance from the Commission for Historical and Architectural Preservation. The department therefore recommends that approval of this application be subject to the conditions: first, that the lot known as 808 South Ann Street is consolidated with the lot known as 1724 Thames Street or Thames Street. And secondly, that all exterior changes, including additions, demolitions, alterations, and signage, are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Ms. French.
The application before the board, 2 conditional uses, both neighborhood commercial establishments, 1 restaurant and 1 office. We have 3 memos in the file, 1 in support from Ms. Hecker, 2 in opposition from Thomas Minton on behalf of Cliff Ransom and nearby neighbor. Just to summarize, there are 35 letters in opposition. We have 8 letters in support, including a letter of support from the Fells Point Residents Association before the board. The issues, essentially, if the board decides to approve the use, it's noted that these are 2 separate lots, and we're going to have a use that crosses the lot line, so it will be difficult, if not impossible, to get those permits without first the lots being consolidated. And let's see, the 2 different properties are zoned differently. So even after they're consolidated, the different zones will exist on the 2 different parcels. I think so that's also something that the board needs to take into consideration. Let's see. So I'm going to, I've got Ms. Hecker is unmuted, or not. She can unmute herself probably now, but she's been elevated as a panelist and she is the applicant. And I believe we have Thomas Minton, who is the attorney for the neighbors also. But obviously, Ms. Hecker will go first, and anybody else she wishes to testify, just let me know and we'll elevate them.
All right. Good afternoon, Ms. Hecker.
Good afternoon. Caroline Hecker, Rosenberg, Martin Greenberg on behalf of the applicant. I believe Dominic Lascola is somewhere in the attendee list. He is the representative from Thames Street Holdings, LLC. With your permission, I'll proceed by way of a proffer. He can certainly answer any questions that the board might have, but I think this will go a little bit more quickly if I can run.
Yeah, I've gone ahead and elevated him to a panelist. That way he's available in case the board has questions.
Great.
That's fine, Ms. Hecker. Go ahead.
Katie, can I share my screen? I have the exhibits that I submitted together with our memorandum. Let me see if I can. Share my screen. All right, you all should be seeing the zoning map. Is that right?
Yes.
Okay. I got the right sharing the right screen. That's always a good start. So the property that is the subject of the application here is 808 South Ann Street. You can see it here in green. It's located right in the middle of the block along Ann Street, between Thames Street on the south and Lancaster Street on the north. It is zoned R8, that's what the green designates, and it backs up to 1724 Thames Street, which is this long, skinny bowling alley shaped lot, which is zone C1. The sort of peach color is the C1 zoning district here. So what you see is that this property is located in the middle of the block, and it's just about 2 doors down from the commercial zone. As we all know, the Thames Street commercial corridor is full of bars and restaurants. And in fact, we have on this corner here, we have the Point in Fells, we have Penny Black Bar and Restaurant over here. The Wharf Rat is this one up here on the corner in the R8 district. Across the street on Lancaster is a salon. So, this is a block that is transitional, that, has some commercial uses, it has some residential uses, but it's definitely not the type of R8 block where it's, a solid block of residential all the way end to end. I also have here, just for reference, the tax plat, so you can see the layout of the properties. 808 South Ann is highlighted in red here, and then you can see it as it connects to 1724 Thames Street. It doesn't seem like there is any dispute about the historic use of 808 South Ann. I have an aerial image. These are all the exhibits that were attached to the memo, but I have an aerial exhibit of the Thames Street corridor. You can see, obviously, it's a vibrant and bustling commercial corridor. The Ann Street property is right up here, right adjacent to it. And as I said, I don't think there's any real dispute that the Ann Street building was historically not used for residential purposes. Most recently, it was an art gallery under the old zoning code, and came in as a conditional use, actually as a different kind of neighborhood commercial establishment when the zoning changed with Transform Baltimore. So when, I guess, just to back up a sec, the 808 South Ann Street building was always used collectively with 1724 Thames Street. They were owned by the Preservation Society, and when the Preservation Society decided to put the properties on the market in about 2018, Mr. Lascola began discussions with them about acquiring the properties and began a series of conversations with local stakeholders about his plans to open a new restaurant that would be primarily in the Thames Street portion of the property, but might also extend into the Ann Street area. And those early plans were quite a bit more ambitious than what we have ultimately landed on. They included a rooftop terrace that would front on Thames Street overlooking the water. They included an outdoor seating area in the rear along Lancaster. And there was an Italian market that was sort of an accessory to the restaurant that was proposed in the 808 Ann Street building. But after many, many meetings with the community association, those plans were scaled back significantly. The restaurant now is only proposed to be a one-story restaurant on the Thames Street side, which includes an accessory dining room in the rear of the 808 Ann Street portion, as well as an office tenant in the front portion of 808 South Ann Street. The second floor of 1724 Thames Street will have another office tenant, as well as some back-of-house space for the restaurant. But to be clear, there are no plans for a rooftop deck at this stage. I know I've heard a lot from the opponents of the project that this should not be approved because one day there may be a roof deck at some point in the future. I don't have a crystal ball. I don't know what the future may hold, but I can tell you that any plans for a roof deck on any portion of this property would include many layers of approval, including the Maryland Historical Trust, CHAP, and the Liquor Board, to say nothing of the Zoning Board to the extent that we needed zoning relief. So it's not something that could be done by right. So in any event, we had a bunch of meetings with the local community association, the Fells Point Residents Association, the Fells Point Task Force, and we met on site, in fact, with a number of the opponents of the project last summer to share the revised plans with them, to show them that we were backing off the rooftop plans, or backing off the outdoor space. We are now going to have an office space on Ann Street, so it will be a much smaller project than what was originally proposed. And we're pleased to report that as a result of these changes, we did receive a letter of support from the Fells Point Residents Association, as well as many other residents in Fells Point, as well as the Waterfront Partnership, which is actually currently a tenant in the 1724 Thames Street building, and they're planning to relocate to the office space on Ann Street. So the Waterfront Partnership would be the office tenant here on Ann Street. You also should have in your file a letter of support from the Canton Community Association and a couple of their individual members attesting to the credibility of the applicant as a responsible restaurant operator based on their experience with his other restaurants in Canton. So with regard to the proposed plans, I have up on the screen, if this isn't big enough, I can zoom it in, but this is the floor plan for the two properties together. They have historically been used together. There is an existing internal connection between the buildings. As best we can tell, that was approved as part of a 2002 renovation that was done by the Preservation Society. But those records, unfortunately, are not available electronically. And so we haven't been able to chase down exactly how that approval came to be. But there's no reason why these properties shouldn't be consolidated. They've operated together for many years. They're in common ownership. So we're proposing to consolidate them. And I think that resolves this issue of whether the accessory dining room could serve the restaurant located on a separate parcel. If they're all one parcel, then what we're basically left with is one parcel that has two principal uses. It has a restaurant that fronts on Thames Street that runs all the way back to Lancaster Street and then comes over into the dining room of this portion. And then the front 2/3 of the Ann Street building would be the second principal use, which would be the office tenant. The zoning code specifically contemplates that properties might be split zoned. Section 6304 of the zoning code provides that, if properties are located in more than one zoning district, then each part must comply with the requirements of its respective district. So the Thames Street portion is located in the C1 district. Everything about that complies with, the restaurant use complies with the C1 requirements. And we're obviously here today on the approval of the R8 portion of the property for a neighborhood commercial establishment consisting of the office space in the front and the dining room, which has 26 seats in the rear. As I said, I don't think there's any dispute about the property meeting the threshold criteria that it be non-residential in its original construction and have a history of non-residential use. This property doesn't have any history of residential use that we've been able to find. And the former art gallery use was basically a different type of neighborhood commercial establishment, which would have come in as a conditional use under Transform when that became effective in 2017. I do want to spend a few minutes talking about the use standards in section 14.328 of the zoning code, because I know that the opposition has raised these as a concern, and I want to address this. The code identifies 7 types of commercial uses that are allowable as a neighborhood commercial establishment in the R8 zone. They specifically include offices and restaurants with no live entertainment and dancing. There was a concern raised by the opponents that because the property is going to hold a liquor license, that all of a sudden this would allow retail sales of alcoholic beverages. That's simply not the case. The liquor board at this time has only authorized the use of the Thames Street parcel for, they've transferred a liquor license to the Thames Street parcel. We're going to have to reapply to the liquor board to extend that license premises into the rear of the Ann Street parcel. But the liquor license in no way trumps the zoning code, and the liquor board does not have the authority to authorize the retail sale of alcoholic beverages on a property that would be prohibited on by the zoning code. So, I don't think that is a legitimate concern. The types of commercial uses that are proposed here are fully consistent with a neighborhood commercial establishment. The use does have a pedestrian orientation, fronting on Ann Street. The idea being that these neighborhood commercial establishments are in fact oriented towards the neighborhood, and that is the case here. The Waterfront Partnerships offices will front right on Ann Street here. That we're not proposing a drive-through facility, which would otherwise be prohibited. The uses are contained entirely within the building interior. As I had mentioned before, just for reference, we had proposed a courtyard area in the rear along Lancaster Street, which is actually on the other part of the property in the C1 district. We're no longer proposing that. That's not on the table any longer. All signs are going to comply with the requirements of the zoning code. The sales of tobacco products are prohibited in a neighborhood commercial establishment. We are not proposing to sell any tobacco products. And then the final thing is about the principal entrance must be a direct entry from the primary adjoining street. And I think everybody agrees that no one wants the restaurant to be accessed directly from Ann Street. There is, in fact, a door back here, and we have an emergency egress door. We could create an entrance from Ann Street, but that is not desirable from anyone's perspective. The purpose of this provision is for the use to be oriented towards the neighborhood and not towards, for instance, the interior of the building. You can imagine a multifamily building which had a retail use of some variety that was accessed through the lobby of the building. The requirement that the principal entrance be located from a primary adjoining street is so that the commercial uses in the residential zone are neighborhood oriented. And that is what we have here. The office use will be accessed from Ann Street, and as Mr. French indicated, the restaurant use will be accessed from Thames Street. So, this is fully within the board's discretion to approve. The board has granted many other exceptions to the extent this is an exception to the use standards for neighborhood commercial establishments in other cases. And I can think of at least one other case at 201 South Eaton Street where the board approved a neighborhood commercial establishment with the principal entrance coming from a side door. So this is not at all out of kilter with what the board has approved in other cases. I did submit a rather lengthy memorandum going through the 14 factors that the board is required to consider in approving a neighborhood commercial establishment as a conditional use. So I'm not going to go through them all in detail. I do want to talk briefly about the Schultz versus Pritt standard, the legal standard for governing the approval of conditional uses. Conditional uses are uses that are presumptively allowable, absent some showing that there is an inherent adverse effect of the use that would somehow be worse at this location than at any other location in the zone. That law is very well settled, and I think it's very difficult to argue that on this block, which is already a mix of commercial and residential, and certainly a transitional block between the heavy commercial corridor of Thames Street and the much more residential areas to the north, that the inherent adverse effects of a small office use consisting of the waterfront partnership, which is already located in the other portion of the same building in the back of 1724 Thames Street, and a small dining room serving an adjacent restaurant that is primarily in the C1 district in the commercial zone. I think it's very difficult to argue that the use would somehow have a greater adverse effect at this location than it would otherwise have at another location elsewhere in the zone. This is exactly the type of location where a neighborhood commercial establishment would be appropriate. It is overwhelmingly supported by the community association, as evidenced by the Fells Point Residents Association letter of support. We respectfully request that the board approve the application. I know we had a couple of folks who were here earlier in support of the application. I don't know that they're still on. I know that some of our folks had some other commitments.
Jonathan Rowland is still on.
Oh, he is great. Yes. If he's here, and Doug Kaufman is the other one that we were hoping would be available. I don't.
Mr. Kaufman is on as well. So I'll
Great.
start with Mr. Rowland and then I'll move to Mr. Kaufman.
Thank you.
Saw you there a minute ago. There we go. All right. So Mr. Rowland, you're unmuted, sir.
Okay, great. Can everyone hear me?
Yes, sir. Go ahead.
Okay, great. So hi, my name is Jonathan Rowland. I'm a 6-year resident of Fells Point. I'm extremely active in the community, including being a member of the Fells Point Residents Association, and volunteer for several community events such as Films on the Pier, which draw thousands of visitors to our historic, eclectic, and lively neighborhood. That's why I was so excited when Mr. Lascola announced that he was purchasing 1724 Thames Street, as well as 808 Ann Street, which has for years been underutilized. Mr. Lascola's plan for an Italian restaurant was a welcome addition for myself and many other young professionals like myself who would call Fells Point home. Furthermore, I've been impressed with Mr. Lascola's willingness to work through community concerns. For example, a third floor rooftop was proposed, which was opposed by many members of the community, including myself. Mr. Lascola listened to our concerns and changed his plans for those concerns, which is not under the current zoning considerations, as well as changed plans for 808 Ann Street after hearing feedback from the neighbors. So all of my interactions with Dominic have been, he's listened to the community first, and he's been a community first operator. I think that's well evidenced by the fact that he has received a letter of support from the Fells Point Residents Association, as well as from the Canton Community Association, which vouched for Dominic as a responsive and community-driven first owner-operator. I think it's very regrettable that we have some residents who seem to be diametrically opposed to this project, for really the only reason that Fells Point should remain a time capsule, which has been quoted in several news articles. Let me be clear, Fells Point is no Colonial Williamsburg. We are a welcoming, inclusive, and ever-changing community that welcomes sensible development, especially when that development preserves the historical look and feel of the building, listens and responds to the community, and brings value to the neighborhood both culturally and financially. This project does all of those things. I'm confident that the proposed use of this property will be an asset to the neighborhood as a whole and will not have any adverse effects on the surrounding community, which includes many existing
for it, the whole string of unintended and ill-advised consequences will fall with a loud and public clatter. Unless the BMZA refuses this petition, there will be no way to make the dominoes stand upright again. Thank you, Chairman Fields. Thank you, members and staff. I appreciate this opportunity.
Thank you, Mr. Ransom, for your presentation, sir. Appreciate it.
Okay, let me go through, look at the hand raising really quickly. I don't, let me look in the chat. If anybody is here in opposition, and you please raise your hand. If there's anyone else that wishes to testify in opposition as well, please put that in the chat. I'm gonna, let's see, Stephen Lampard, I believe. All right, there we go. Mr. Lampardi, Freddy?
It's Lampredi. Thank you.
Thank you. Okay.
Mr. Chairman, Commissioners, thank you for giving me an opportunity to chime in.
Certainly.
I worked in Fells Point, both as a paid person and a volunteer for about nearly 20 years, and I'm very familiar with the property that's being discussed. I worked in that area as a volunteer, and I helped set up the museum when the Preservation Society had their museum in the 1724 space. What I'd like to call attention to is the courtyard which exists behind the Thames Street property on Lancaster Street. It's not a very large place, but it's always been a very quiet place. And people live across the street from it on Lancaster Street. And plans that we have seen for this restaurant involve a trash room in the place where, in the back of the 1724 Thames area, and presumably a door right there. And no other restaurants take their trash out via Lancaster Street. This is probably going to happen in the future, and it's going to impact residents. One could say, oh, no, we have another plan. We'll take it all to the front. But we don't really think that that's the way the employees of the restaurant will behave, because they're going to take the shortest path to take their trash outside. The other effect of the restaurant on this and the dining room that's being discussed in 808 on this courtyard is that there is easy egress to that courtyard. Double doors. And those double doors will be in the new lounge of the restaurant, where people will be talking, smoking, well, not smoking, talking and laughing. And well, they'll come out into the courtyard to smoke their cigarettes. And that's right behind the homes of several long-term residents on that block. And it's going to diminish their quality of life up until 2 a.m. in the morning. So these are the kind of effects that the letters of opposition have been outlining. I hope that every commissioner read all 35 letters of opposition. I'm hoping that every commissioner read every letter of opposition, because they come from the people. They come from the people that live in this area and are going to be affected. And my last comment, and we'll wrap it up, is that, as Mr. Ransom noted, there is always a series of degradations, or as I say, dominoes, the domino effect. And we've been seeing that effect in Fells Point over the past 20 years. where more and more businesses take more and more space and have more and more employees and more patrons, and that creates congestion. It has grown in the years that I've been there, and it shows no sign of stopping. And so my final, no, we're not going to talk about that. My final comment is that some developers will tell you that more is better or more is more, and some people who we've heard from in welcoming this development are saying that we don't keep people out. It's not a time capsule, but it sort of is a time capsule. And to value what is valuable and what is historic is one of the traditions of Baltimore, at least of recent times. And so what I would say to you is more is not necessarily more. And that's, we keep getting more, just more. And I thank you once again for allowing me to comment.
Thank you, sir.
I'm going to go through the call-in users now. I don't see any additional new hand raising or anything in the chat. So we'll go through the call-in users, and then I believe that will be it for opposition. All right, so if you're here to testify in opposition for 808 South Ann Street, when you hear two beeps, please speak up. Okay, moving to the next one. Okay, moving to the next one. Moving to the next one. Moving to the next caller. And the next caller. And now the last caller. Okay, so that's it for, I believe, opposition, presentation, and testimony for this matter.
Okay. If we turn our attention back to Ms. Hecker then for the last word. Ms. Hecker, I believe this is contained in your initial memorandum or your memorandum that has been presented by you, but in response to Mr. Minton's statements, could you briefly, cover with the board how you believe we're able to exercise discretion to grant the application with regard to those additional factors that Mr. Minton in his argument suggests have not been met, specifically the areas of parking, which was number 2, the entry, the live entertainment, and the liquor license issue.
Yes, absolutely. Thank you, Mr. Chair. Yeah, I was making some notes while Mr. Minton was speaking, so I'll respond to the issues in the order that I have them written down, but feel free to
not a problem
me if I'm going the wrong direction. With regard to the liquor license, because that seems to be an area of concern, the application that we made to the liquor board was to transfer an existing BD7 license, a class BD7 license, from an establishment that had gone out of business on Broadway over to 1724 Thames Street. And the liquor board approved the transfer of that license to that location. The license itself does allow retail sales of alcoholic beverages, and it does allow live entertainment. It does not allow either of those things, or for that matter, any sales of alcoholic beverages in 808 Ann Street. We have to go back to the liquor board for any kind of approval, even to have a glass of wine with dinner in the 808 Ann Street building. However, the liquor board and the liquor license cannot trump the zoning code. Regardless of what that license or that class of license would otherwise allow, if the zoning of 808 Ann would not allow it, the liquor board can't authorize something that the zoning code would otherwise prohibit. And that's clear in the zoning code, which specifically provides that for split zoned properties, each respective portion has to correspond and comply with the requirements of its respective zone. So the fact that a portion of the property is located in the C1 district and a portion of the property is located in the R8 district, doesn't give the R8 portion the C1 privileges. It has to stay with whatever the underlying zoning is. So the most that the liquor board can approve, and to be clear, they have not yet approved it, is on-premise consumption of alcoholic beverages in 808 Ann Street in a dining room. They cannot approve retail sales. They cannot approve live entertainment. So then with regard to the parking issue, the zoning code is clear that for neighborhood commercial establishments that are 2,500 square feet or less, no parking is required. The whole of 808 Ann Street is under 2,500 square feet, so there is no parking that's required. Now, I heard Mr. Minton suggest that if it's consolidated with the Thames Street property, then it should have to provide the parking that the Thames Street property would have to provide for the restaurant. The Thames Street property is zoned C1. The C1 district does not have a parking requirement. There's an exemption in the code for all uses in the C1 district. So there's no parking that's required for that restaurant or any other restaurant that's located along Thames Street. So whether the lot is consolidated or not, it is exempt from the parking requirements in both cases, and a variance is not necessary. We also don't think of any parking is really necessary as a practical matter. Fells Point has a great pedestrian experience. No one is, this is not a destination place where you're driving specifically to this location. You're walking around Fells Point, popping in for a drink or for dinner. The office user on Ann Street is the Waterfront Partnership. They're local. They're based there. They're in 1724 Thames Street right now. So to whatever extent they have cars, their employees have cars, and they're coming to that location, they're already doing that today, which is one of the many reasons why this particular use at this particular location, the inherent adverse effects of this use are certainly better at this location than they otherwise would be, because this is already a commercial use. It's already this commercial user, the Waterfront Partnership, who's just in a different part of the building. With regard to the location of the entrance, in no way do I think that that is a throwaway requirement in the zoning code. When the zoning code says something, it means what it says. And it says that all uses have to have a primary entrance on the adjacent primary street. And so what we have when we consolidate the lots is two principal uses. One, the restaurant, for which the primary entrance is on Thames Street, and the second is the office use, for which the primary entrance is on Ann Street. And as the planning department indicated, that in their view satisfies the requirement that there is an appropriate primary entrance to the use that fronts on the street where the use is occurring. And, in this case, the vast majority of the Ann Street building is going to be used for the office space. It's only the back portion is going to be part of the restaurant, and that portion is not going to be accessible from Ann Street. The idea is that restaurant, that dining room provides an extra dining room, a little more seating area for the restaurant, but there's not going to be anyone coming out that egress door into the garden or, coming out to smoke cigarettes. That's not at all the intent, and it won't be open to guests of the restaurant to come out that way, or to employees to come out that way. And I think everybody agrees that that's not a desirable result, to have that as an access way. So, I think it's squarely within the board's discretion to determine that the primary entrance for the Ann Street property is for the office use and it fronts on Ann Street, and that the primary entrance for the restaurant is the entrance on Thames Street. And then I guess finally, although I covered this a little bit, is the live entertainment. Live entertainment is not allowed in the R8 district as part of a restaurant as a neighborhood commercial establishment. There's just simply no way to have that authorized. We're not intending to have live entertainment on this property. There will be live entertainment in the Thames Street portion, which is properly zoned for it. In fact, I would point out that the Thames Street portion is not just C1, it's C1E. The E stands for entertainment. It's intended to be an entertainment district. And so all of the entertainment will occur in the Thames Street portion. And that's, again, specifically what the code contemplates when it talks about having split-zoned properties, that each respective piece of the property has to comport with the requirements of the underlying district in that area. I think the overarching theme seemed to be that this was going to create this domino effect of encroachment of commercial uses into a predominantly residential street, and that's simply not the case. There's an existing commercial use there. There's been an existing commercial use there for many years. The tenant that's proposed in the office space is a tenant that's already there, that's going to, move into this space from another space in the adjacent building. And it's a tenant that serves Fells Point by providing all kinds of services to the area. It's a tenant that you want to retain in Fells Point. And the restaurant use, again, is not going to be fronting or spilling out onto or accessed from at all the residential area. It's difficult for me to understand how the proximity of the historic Robert Long House or the historic garden that's next door has any, how this proposed office use in this dining room has any impact on that. I haven't heard the opposition articulate what concern they have other than just sort of an amorphous, this is an encroachment into residential. And again, on that point, I would say that this is a block that is not entirely residential. There are many R8 blocks in the city that are residential end to end. This one on 3 of the 4 corners on this block has a bar and restaurant. All we're proposing to have is a little office that's less than 1,000 square feet, that's open from 8 a.m. to 5 p.m., regular office hours. It doesn't have night business people coming in and out. Like, you can't think of a less impactful use coming into this block. So, I really submit to the board that the inherent adverse effects of the proposed office use and the ancillary dining room with 26 seats in the back, which will again not be accessed from Ann Street. I have a hard time seeing how the inherent adverse effects at this location are somehow worse than they could otherwise be in the R8 zone. The only thing I would just remind the board at the end is that this project has been through many layers of review so far, and it has been approved at every step of the way. The Maryland Historic Trust has approved what we are proposing to do. CHAP has approved what we are proposing to do. In fact, CHAP actually approved the concept for the roof deck before we backed off of that, and that is what Mr. Ransom alluded to, what they are challenging in court, sort of moot at this point because the roof deck is off the table, but CHAP has approved the minor exterior painting that we're doing, the signage that's proposed. The planning department is recommending approval here. The liquor board has approved the liquor license for the Thames Street portion. So, this is something that has gone through extensive review already, and I think that the zoning board's approval is consistent with what the other agencies have done in this case. So, with that, I would submit and request that the board approve our application.
Before we move on, we actually had someone who was trying to get in to also speak in support, but I guess it broke up. So it was John Rohr, and he just put in the chat to all the panelists. I just want to point that to everyone. As a Fells Point business owner and resident of the 700 block of Ann Street, I would like to state my support for the business, especially in the service industry and community associations. Make Fells Point what it is today. Without their collaboration, we would not have seen rejuvenation in our neighborhood that has occurred over the last 5 decades. I'm pleased to see the resident association in support. Thank you, John Rohr.
Yeah, we've seen that. And
Okay, good. I just want to make sure.
Okay. Thank you, Ms. Hacker, for your presentation. Are there any questions for Ms. Hacker at this point on the board? No? All right. Thank you so much.
Thank you very much.
All right. Well, as we move on, we received contact from Mr. Stewart, who is the owner at 2021 169 630 Harvey Street. He was unable to attend, and we are going to put his case on the May 10th docket. So we only have 1 case left now.
Okay, I'm sorry. So
Can I request like a 5-minute break before we 5 to 10 minute break before we go into this new one?
Sure.
I know it's late, but I need to.
No. Yes. We can do that.
Okay.
Yeah.
How long?
Give me 10 minutes.
Okay.
Thank you.
Okay. Katie,
Yes.
normally 169 is postponed, or where we are?
Yes, 169 is postponed to 5/10.
Yeah.
And I will note, we just had a message in the chat from a Miss Henry for her appeal at 3602 West Rogers Avenue. I did not have that on the docket today. We heard this on November 30th, and it was postponed. It looks like there was an exchange back and forth with she and Roxana, but I'm not exactly sure what happened, but it didn't get on our docket today. So we're not prepared to hear that case. So I've just put in the chat that we will put her on the May 10th docket. Because it's too late as far as the posting goes for 4/19. But we can put her on the May 10th docket and just.
Okay.
So I think that we're just down to our last case, which is 901 Bennett, I believe.
Everybody back?
Let's see. I believe we are. I think I see people.
Katie, what's the status of the 202 East Preston Street?
That one we heard. That was oh no, it wasn't. I'm sorry. That was she didn't post. So she's going on, she has to redo that one. And I want to say, Becky, did I say we would put her on 510 too?
Yeah, so this is postponed for today.
Yeah, because she didn't post.
Okay.
All right, if we're ready, I'll call the next case.
Okay.
Let's do it.
Okay, calling, once I get my record, 2022-115, 901 Bennett Place. The appellant is Precious Ogana, and this is a request to use portion of the premises, the ground floor, as an office for wholesale car dealer, tag, and title service. Now hear from planning and staff.
Thank you. Planning Department reviewed this application. Noted this property is in the Harlem Park 2 Urban Renewal Plan area. This particular plan does not specifically prohibit the proposed use. However, the plan does prohibit in the residentially designated portions of the Urban Renewal Plan area, which includes this property. Uses are to be allowed as in the R8 and OR2 or office residential zoning districts. And neither of these allow motor vehicle dealerships. So one of the questions before the board obviously is whether this in fact constitutes some form of motor vehicle dealership. Property was last authorized for use as a multifamily dwelling and a retail goods establishment with no alcoholic beverages sales. Those uses are presumed to continue. The department believes this application is very similar to a previous appeal heard over a year ago, number 2020-208, filed by the same applicant and heard by the board on December 15th of 2020. And that the board determined at that time that a motor vehicle dealership was not permitted at this location, and that the operation of the proposed use would be sufficiently detrimental to the residential community surrounding the property that it should not be approved as a conditional office use either. The department is therefore noting another point, and that is that a neighborhood commercial establishment use, which this would be required to qualify under, is not to be automobile oriented. And the previous application established that patrons of the proposed use would leave untagged motor vehicles on the street in the immediate vicinity of the proposed use, which fundamentally changed the proposed use from pedestrian oriented to vehicle oriented. For these reasons, therefore, the planning department recommends disapproval of the application because it is substantially similar to previous appeal number 2020-208 for the same use for the same portion of the premises, which was disapproved by the board on January 20th of 2021. Thank you.
Thank you, Mr. French.
As Mr. French stated, the request for this is as a neighborhood commercial establishment office. However, they're seeking, it's essentially a tag and title business. We have, as you have in your packet, lots and lots and lots of neighborhood opposition. Planning also recommends disapproval based on the motor vehicle use. And as Mr. French just stated, issues before the board, this is essentially the same application that was disapproved by the board 1 year ago, BMZA 2020-208. The board had a copy of that in the file. And the community testified that there are multiple untagged vehicles parked along streets in front of businesses, which takes away parking from residences. The board found the scope of the activity and the on-street parking issues testified to at the hearing were not in harmony with the zoning district. The last authorized use of the premises is for a grocery store on the ground floor and a 2-unit multifamily dwelling on the upper floors. Again, most of the letters did discuss the impact, the negative impact on the neighborhood, trash, traffic, parking, and the number of vehicles that would be parked and located. We have several neighborhood associations as well who submitted letters in opposition. So at this point, I'll go to the applicant, Miss Organa, and elevate her to a panelist. So Miss Organa, you're now a panelist and you're unmuted.
Hello.
Good afternoon. Go ahead and tell us about your project.
Good afternoon. First and foremost, I want to say a very big thank you for the opportunity to be on SECT. Firstly, my name is Precious. I'm a member of the Army National Guard. I've been in the neighborhood for close to 8 years, and the purpose, firstly, of I'm not doing a dealership where cars are being sold. It's just an office where I can do like day-to-day activities for wholesale dealership. So meaning I don't sell cars in the neighborhood. Wholesale dealership by the MVA only requires the applicant to have a place for an office where I can have documents and all that. That's for one. And secondly, for a tag and title, which is in line with the wholesale, with a wholesale dealership. In that case, people only come to tag and title on appointment, especially when they just bought a car somewhere and they need to register the car. You can't drive a car except the car is being registered. You know, there is no parking issues in this environment. I've been here for 8 years. I live in the top floor around the Bennett place. We own the property, and there is no cars parked all around the vicinity as was claimed. It's right there. I'm around the vicinity right now, talking right now from the vicinity. There is nothing like that.
Is there any business activity taking place at that location presently?
We got a grocery store that is approved, that is at the vicinity. Also, the owner of the grocery store is aware of the business. Apart from that, there is no business activity taking place in the vicinity.
So are you proposing to have this
And
title?
I'm just trying to point out it's not a retail car dealership where we sell cars. Pardon? Can you say that again, sir?
You're breaking up a little bit. So the tag and title operation is going to be operated adjacent to the grocery store?
Yes, sir. And it got its own entrance and tag and title. Technically, on appointments, people only register car after they bought the car somewhere, and they've got to come to register the car before they can drive the car. So there won't be any need for parking issues and all that. The whole place is open. There is no parking issue. There is no untagged car parking in the whole of this road. I'm right in the vicinity right now, and that's not true.
Were you involved with the application to this board a year ago? Well, in 2020?
Yes, sir.
And what's the difference between that application and this one?
Okay. In 2021, when I did the application, at the day of the zoning, because I was supposed to do an appeal, I did state at the day of the zoning that while I posted the sign, I had issue.
Hold on,
someone
we're having
Is there
said it was
someplace you
not.
can go?
Yeah. Yes, sir.
Is there someplace you can go where your signal is steady? Because we're only hearing every other word that you
You're going in and out, sir.
say right now.
Okay, I'm trying to
Do you
change
do you know where there's
location.
your best services?
Is it better off now?
It may be.
Hello?
Go ahead and continue to talk.
Okay. When I had the application the last time, I was literally I wanted to appeal it because someone spoke as regarding the car issues and all that, but I wasn't available to appeal it. I was deployed, for service, and that was why I came back like a couple of like 2 months ago or so from deployment. So first and foremost, I can't be parking cars untagged when I'm not even a car. I don't own a dealer listing, and I'm not I'm not in the city at that moment. So the difference between this application and that application is that first and foremost, it's an office. It's not a car sales. There's no cars parked along the road. I'm right outside right now. I can turn on my video camera if you want to see it, if that's allowed. I can turn the video camera on right in front of the property I'm about to use, and if the board allow that.
Sure, we allow it. If you'd like to do it, feel free. This is your opportunity to do a presentation. So if you think it's beneficial to you, go right ahead. While you're doing that, tell me what the application was for. Your prior application was for. What business were you seeking to establish?
For the prior application, it was for a dealership.
Okay.
This application, it's simply for just an office.
I understand.
Yeah. So this is the front of the 901 Bennett
You
Place.
gotta keep your voice up, sir.
Okay, this is the front of the 901 Bennett Place. I'm right outside now.
Okay, we can't see it.
You can't see it.
You have to turn your camera on.
Okay, just a second. Trying to start my video. Can you see it now?
We can see you. I don't know if that's your signal may not be coming through because you appear to be frozen. Okay, now we can see you, sir. And tell us what you're showing us. Looks like we got a signal delay here.
I'm using for the office. So this is the whole front of the building.
It's the green building that's depicted in the corner with what we see as a corner of the screen. The green building?
I don't see anything.
Looks like it's to the left of his head.
I don't see his head either.
So if I can share my screen, I can pull it up and he can tell us what's pictured in it. I think I can get a good swivel going.
Great. Mr. Ghana?
Now, mind you, this is what I have is from November 2020. Oh yeah, there we go. That's what yeah, it's just he's turned to the side, but we can't, maybe there's not enough bandwidth for him to do
I think that's the case.
video call and yeah. Mr. Ogana, we can see the building, but we can't hear anything you're saying.
I think he's just delayed. Now he's got to wait to. Like being on the moon and calling down to Houston. Mr. Ogana?
Hey, James.
Yes, sir.
I'm a little bit confused. When I look under requested use relief, the appellant has requested to use premises for professional office, wholesale auto dealer, and tag and title service. So that's actually what he requested, the wholesale auto dealership?
I think what he's trying to say is he's seeking to use the building as an office for a wholesale tag and title. The question is where that other business is. If it's not on site, which
That's what I understood him to be.
yeah, can't be. So the uses, this is an office for those particular uses, but an office only.
And Martin does have a good question.
Do we lose him completely? I don't.
It sure seems like we've lost him. Yeah, no, I don't. He's not listed anymore as a participant. I know we've got a lot of people still hanging on for this.
Hope he had some charge in his phone.
I guess we'll give him a couple. Well, let me see if there's a way I can. Yeah, let me see if this is.
And let me know if you want to see.
What you have, Sabrina?
Yeah.
That's Katie's got to give you the ball, I guess.
Well, that was a mistake. That was not him. So that's what I get for answering the phone when it's just a 443 number. I was hoping it was our applicant. All right, let me okay. Let me pull up the WebEx and see if there's a way I can contact him.
There's no way this could be a car dealership.
No.
Well, not never say no.
Right.
It's definitely residential.
Found him. He's in the attendees, Mr. Organa.
Yes, ma'am. I'm sorry. I had a network issue.
Okay.
Yeah.
All right, Mr. O'Donnell, can you see us?
Mr.
Yes, I can see
Just on
you.
the phone. You can see us?
Yeah, I can see you.
Okay. Sabrina, do you want to see if you can get the ball and show what you?
Yeah, Mr. O'Donnell, I'm gonna pull up. I'm gonna share screen. I have your building, the Google image that I can move around in. That's from November 2020. So you can talk me through it, and I can move it around while you tell us what we're looking at and what your plan is. Okay.
Okay, ma'am.
Okay, hold on. Let me share my screen.
Sabrina, I just gave you presenter privileges.
Okay. It's asking which screen I want to share. Huh. That's nerve-wracking. Okay, can you guys all see? Mr. Ogana, can you see?
Not yet.
I'm not seeing anything yet.
Okay.
There you go.
There you go.
Oh. All right. So, Mr. Ogana, this is the grocery store, right?
Yeah, the grocery store is by the right.
Okay. Tell us what else we're looking at.
Towards the front. The entrance to the dealership is towards the front, and there is no cars parked right outside to the dealership, to the office that is about to be done right there. And the office does not involve sales of cars in the premises.
You say the office is for a dealership?
Mr. Ogana? Mr. Ogana? I mean, he's got a, looking at that signal, looks like he.
Yeah. Oh, it's because he's going live again. That's why. He's got, or not going live. He turned his camera back on.
All right, Mr. Ogana?
I can unshare my screen then. Mr. Ogana, are you there? So when you turn on your camera, it uses a lot of data, and so we can't hear you talking. Your phone has decided to sacrifice sound for picture. So whenever you turn your camera on, it's using your limited bandwidth to show us what you're looking at instead of us hearing you. So you choose which one you
We
would
don't need to
like.
see anything.
And I can. Yeah, we'd rather hear you. Definitely frozen.
So did he verify that this is the picture of where he's trying to have the business? Okay.
Yeah, so this glass door right here, he says, is the door to the business. I think this white door back here is to the residences, and this front door on facing Bennett Place is the grocery store door.
Okay.
I don't understand this wholesale auto dealer.
Let's see if we can get a hold of him and see if he can tell us about, where that business is in relation to this.
Seems to me you'd have the office where
He
the
appears
business.
to be in front of the white door. In front of the white door right now.
Oh.
Actually, maybe I'm wrong. Maybe the 901 is the door to the office. I don't know what that
Hello?
glass door is.
Yeah, Mr. Ogana, can you see the building that's?
Hi.
Yes, I can see the building you're showing.
Is the white, where's the door to what you proposed to be?
Okay.
The white
going
door.
around it.
Mr. Ogana, turn your camera off, please. So that way I think it will help with just the audio.
Oh, okay.
My bad, y'all. I'll go back. I'm going back to it. I just zoomed somewhere I wasn't prepared to go. I'm headed back. Here we go. There we go. All right.
Mr. Ogana, where's the front door to the?
All right, Mr. Ogana, you said that this white door right here is the door to the business that you are in front of us today about?
Yes, sir.
All right. Where is the wholesale car dealership for which
Okay.
the office is going to? Go ahead.
So I guess our main question, what we've been talking about, I don't know if you could hear us. Yeah, is this, where are the cars for the wholesale? If you're running an office for a wholesale car business, and this is the office for it, in order for you to sell cars, they have to exist. So where are they kept?
Okay. For a wholesale car dealership, you don't need a lot. What you do is you deal with retail dealers. So what you do is you help retail dealers go to the auction, buy cars, and transport to the retail dealers. So a wholesale dealer only need an office where they do documents and all that. The MVA makes it completely clear. There's difference between the wholesale dealership and the retail dealership. For a wholesale dealer, you don't need a lot. You don't need an office. You don't store cars. What you do is you got retail dealers that you work with as a business entity, and then you go to the auctions, buy cars on their behalf, and then it gets supplied to the dealer. So you don't deal with the public as wholesale dealer.
At the tag and title shop,
I understand.
do you intend to place tags on vehicles that arrive for their paperwork?
Now, for the tag and title shop, when someone somewhere else buys a car and needs to get it registered, then they can come and I get it registered for them and send it to the MVA. So I'm just like an intermediary with the MVA for the tag and title. So I won't be storing cars. I won't be selling cars to the public. All I'm just gonna do is just an office to be able to keep documents and do all day-to-day transactions.
Okay.
All right, I'm gonna unshare myself now.
But you indicated that your previous application was for a dealership as well. Is that right?
Yes, sir.
Any more questions for Mr. Ogana before we hear from
It's a wholesale dealership, right? Not a retail dealership, correct? That you're asking.
Yes, ma'am.
So to be clear, the prior application was for wholesale, not retail, you're saying?
No, this application is for an office for wholesale.
No, I mean the prior application, that was for also wholesale, the same exact thing you're applying for now, or something different?
Yes, something different. The former one involves cars, but this one, no cars. I'm just going to be an intermediary.
You were going to have cars at that site that you're asking for the office now?
No, I'm not going to have cars here.
No, and previously you were going to have cars, you're saying?
Yeah.
Okay.
All right. Any additional questions for Mr. Ogana before we? Mr. Ogana, anything else you want to tell us about your application?
No, for now.
Okay. If there are no other questions of Mr. You get the last word.
Okay.
If there are no other questions of Mr. Ogana, we'll go to the opposition so we can at least hear what they're saying.
Okay, we have, there was Miss Robin Heath, who was on, had to leave. She put in the chat and wanted me to share this with you. She also submitted written testimony, which the board has. It says, I'm here on behalf of Fight Blight Baltimore to reaffirm our written testimony. Simply, there are far too many unanswered questions regarding health and wellness impacts on the community and valid concerns regarding this use. As Blight to move forward with this proposed conditional use application, I urge the board to reject the conditional use outright and encourage the applicant to work with us to make the neighborhoods of Harlem Park, Heritage Crossing, and Upton healthy, safe, equitable, and economical and vibrant. So that was Robin Heath, who had been on, who had to leave. So
before you go on, let me just ask a question. I'm so going to back up. Mr. Ogana, did you talk to the community, any community organizations or members about your proposed plan?
Yes, sir. I spoke with a couple of community neighbors and members also. And I think I got a couple of them on the line also.
Okay. Did you go to any community association meetings or anything like that?
Association meetings, no.
How did you choose the people you spoke with?
I did spoke with the businesses in the community, like around the vicinity. The neighbors in the vicinity, both directly opposite, adjacent the proposed site of use. And that was what I did.
Wait a minute. You just said there are a couple of them on the line. Do you have people here that are testifying in support of your business?
Yes, sir.
You know who they are?
Yes, sir.
We want to hear from them before we go to the opposition.
Okay.
I have a Julie Ajoke. Is that
these names, Mr. Ogana?
Yeah, Julie is one of them.
okay? All right, and then we'll start with her. All right, so Miss Ajoke, you're unmuted.
Yes, I am. Good afternoon, everybody.
Good afternoon, ma'am. Go ahead.
I live around in the neighborhood, and I really don't see any problem with him doing a business there because he's actually doing a wholesale business, which means when people come, they come into the office directly. They don't have to, he doesn't have to park cars outside or bring cars around the neighborhood. So I support his business because it's a small business that is just growing and coming up. So I really support his business. That's all I have to say for Mr.
Where do you live? You said you live in the neighborhood?
Yes, sir.
Where do you live?
Say it again, ma'am.
I live.
I need you to be more clear. Can't hear you.
I live at 223 North Frontier Avenue. That's where I live at.
I didn't hear the street. 223 what?
223 North Frontier. Fremont.
Forment.
Yes, Fremont Avenue. Yeah.
Fremont?
That's it, Fremont.
Okay.
Yeah.
Thank you. Anyone else, Mr. Ogana, who testifying in support?
Looks like we have a Kevin Kington. Is he support?
Yes, sir.
Okay. Mr. Kington? All right, Mr. Kington, you're unmuted.
Oh, good day, everybody. Thank you for the opportunity to speak on the panel. I just wanted to say, I don't actually live in the area, but I'm always there most of the time, like, because I'm a graphic designer, and most of the time, most of my work I have to do in the area. So I have a buddy who lives in the area. So most of the time I work down there. So I'm always visiting. And all the time, with the work he's done in the area and the building as a whole, he's helped renovate the whole place. It's amazing. And usually he ensures that it's neat. I don't usually see any cars parked out there. And I don't see any threat to his business as far as the area. As to me, I'm gonna rather say he has helped bring in a lot of development in the area with he's helped install security cameras around the area, and he's helped just make it look good. He helped paint around the area, and it looks neat and presentable. And like I said, it's not always cars parked around. And it's not a threat to the neighborhood. So I would say I'm a great favor.
Thank you, sir.
Okay, anyone else? I don't see any additional hand raised, nothing else in the
I
chat.
got okay on the line too.
On whose line? Who?
Okay, wants to.
Hold on. Oh, as a call-in person?
Yes.
All right, I'll go through the call-in users. So if you're here in support of this particular application, you hear two beeps, go ahead and speak. After this, we're going to move to opposition.
Yeah.
Okay.
Hello.
Hello, are you here in support?
I'm sorry, your name again,
Yeah, this
sir?
is Prince speaking. Can you hear me?
Yeah, we're going to need you to spell your name, sir.
Okay, my name is Prince, Prince Amuzie.
Okay, go ahead, sir.
All right, I'm just taking my consent to the approval of this docket. Just to reiterate what he said prior to this time, I am a retail business person, and I understand that we deal with lots and we park cars as required by law. And with a wholesale business, all you require is basically an office to process your documents, because most of the documents come from the auction and you ship out the titles to the retailers, and that's it. Now, also, when it comes to doing title, I understand that sometimes people buy cars from the auctions and they want to register their cars, and they have to maybe use an Uber or something and drive down to get a tag and go back to the auction. Stuff like that doesn't require a parking spot. And I've also been a wholesaler before. I've used even an apartment complex, which was approved by MGA, in regards to just a wholesale, not a retail. Like wholesale is different. Wholesale can buy a car from the streets and only sell at the auction. They cannot buy a car from the streets and sell it on the streets, which means that he cannot sell the car legally as his lot. So they only buy a car from the streets and sell at auctions, or buy somewhere else and sell at the auctions. So the transaction is between the outer environment to the auction, not to the environment. So that place is just for paperwork. He sits down, he signs documents, he ships it out to the people, and that's it. So I do approve that, because the place has been pretty calm so far. I remember a couple years back, Bennett place used to be very, very awkward. People walking around and doing a bunch of stuff. But now it's pretty quiet. Security-wise, I don't see a lot of people roaming around or doing illegal things, because there's a lot of security cameras and a lot of reinforcement that have been done a couple of years back. So I think there shouldn't be any problem just having an office for a wholesale and dealing with the auction, because that's all about paperwork. So I do consent to this application. Thank you.
Okay. And sir, do you live in the neighborhood?
No, I don't.
And how are you familiar with the neighborhood?
I'm like I said, I'm a retailer, and I'm a retailer, and I drive around there. I buy cars from the city, I buy cars from the county, I buy cars all over the states. So I kind of know about the city. I know about Bennett's place. There's a couple of times that I've had people that bought cars from on that street, and also I know him. We've been a business partner for a while. He does wholesale. I did wholesale before I moved to retail. So I've done, he's helped me out with my business sometimes. Sometimes I drop him off there, because the guy that owns the business also, I think he does real estate or so. So I'm familiar with the streets. I'm familiar with Baltimore City. I've been in the United States I've lived around here for about more than 10 years. So I kind of know around the city. I mean, I know around the city. I know about the counties. So I'm kind of familiar with the cities and which cities are pretty good. Like Cannon, South Point, I know I could freely walk around there, and some places I know that are really sketchy. You have to be careful. But, for past couple years now, based on my experience of hanging around there, it's been really quiet. I think the state has done a pretty good work in keeping the place pretty calm.
Okay. Thank you, sir. I appreciate your information.
Hey, James.
Thank you.
Did he say that he drops cars off at that location?
Sorry?
I thought he was talking about an individual. Did you? The question was.
I don't know. I couldn't.
Did you drop? We couldn't quite hear you. Did you say you dropped cars off at that location?
Me? No. I say I pick him up sometimes when we do business. And let's say I'm buying a car, he goes with me to pick up the car. And once we drop the car at the auction, I drop him back home. So I drop him off home. Like,
You dropped Mr. Ogana.
Oh, you're talking to Ghana? Sorry. Okay.
No, we're just trying to be clear what you're saying. You didn't say that you dropped cars off at that location. Did you?
No, I don't. Like I said, he's not done business there. I'm the wholesaler. I'm the one that's doing wholesale. He helps me with the business. So I have my own wholesale.
I understand.
Place, which is
just
the auction.
Just wanted to clarify what you said you dropped off.
No. We don't. No, I drop him off. Drop him off.
Drop him off.
Ghana off.
Okay,
yes,
that's what I thought.
Drop him off at his home. Yes.
Okay, thanks.
Yeah.
All right. I think we're good now to go to opposition.
I still got a neighbor that's still online.
Okay, a call-in neighbor?
Yeah, caller.
Who's that?
Okay, well, I'm going through the callers now, so we'll see. Hopefully this next one is your neighbor.
Yeah.
Are you here to testify in support? Going to the next caller. Are you here to testify in support of this application? Going to the next caller. Are you here to testify in support of this application? All right, going to the next caller. Are you here to testify in support? All right, I only have 2 callers left. Are you here to testify in support?
Yes.
There we go.
Can you hear me?
Yes, go ahead and state your name, ma'am.
Okay, yes. My name is Nancy, and I live right across the alley from, from the place where he resides.
Nancy, what's your last name?
I'm right. My name is Jenkins.
Okay, Nancy Jenkins.
Mm-hmm. I don't see it as being a problem. It's not going to be bothering or blocking anybody if he's just doing, paperwork. Just, people just come to do their paperwork. I don't see a problem with it.
Okay.
Yeah, I don't think it bothers anybody. It shouldn't if he don't have people, well, he wouldn't have cars lined up everywhere if he's not going to have, he don't deal with the cars personally, and it's just paperwork. They come down with their little signatures, just do their little paperwork, and that's it. So that shouldn't be a problem.
Okay. Understood. Thank you, ma'am.
Okay. You're welcome.
Okay, so I'm going to go to the last caller to see if they are here in opposition or support. Okay, are you here to testify in opposition or support on this matter?
Hello.
Hello?
Yeah, can you hear me?
I can.
Yes.
Okay, my name is Okenwonsu.
You're going to have to spell that for us, sir.
OKEY NWOSU.
Okay.
Yeah, I'm actually his neighbor. I live on the 2nd floor.
Okay, are you here in support or opposition to his application?
I'm here to support him. I'm in support.
Okay, go ahead, sir.
Yeah, what I'm trying to say is just that he's just doing paperwork over there, and crowd don't have to come to his office. Maybe just one person, 2 people, and that's just it. It's never been a problem there. We've never had problems with saying, okay, we have a whole lot of people trooping into your office and stuff like that. It's just a very peaceful place, and his office is just very conducive for the big kind of business that he does.
Okay.
So I approve him.
All right. Thank you very much.
You're welcome, sir.
Any more callers, Katie?
No, that was the last caller. So at this point, we'll move to opposition testimony. All right. So if you are here to testify in opposition to this particular matter, please either raise your hand or put your name in the chat. Let's see.
And if the callers could bear in mind that what is before the board is an application for an office only, not for a car dealership. That being said, we'll hear from you.
Okay, I've got Janet Allen. I'll unmute her. Miss Allen?
Hello, how are you?
Good afternoon, ma'am.
Can you hear me?
We can. Go ahead.
I am with the Heritage Crossing community. Our community is right across the street and surrounds.
Ma'am, I'm not sure where you're directing your voice or your phone, but we can hardly hear you.
Can you hear me now?
We can, if you would keep your voice up.
Okay. I'm with the Heritage Crossing community. I am on the board, and we stand with the planning department and ask that you will deny Mr. Precious Ogana the application. Number one is that he has broken trust with the community. last December of 2020, when he applied for that dealership, he had cars lined up and down the street that were not tagged. Miss Sharon that showed the outside of the of his business just now also showed how many cars were outside untagged. And when we received this invitation for the hearing, the invitation indicated that he was looking for a car dealership license, a wholesale car dealership license, and now he is changing up. We do not believe him. He has not helped the community. He has not come to anybody in the community or to the association to ask or to speak with him. This 901 Bennett Place has been a perennial problem with us. He has not helped us to get security cameras, or maybe we can say he did because 901 Bennett Place has been a nuisance establishment, and security cameras was put by there because we had so many shootings and murders in that particular place of business. And so we are asking that you will deny the petition for it. When these other people are talking and saying that they are neighbors, we're not familiar with them. In our community, we kind of know, everybody knows everybody. Someone that said they are at 232 or 220, 32 North Fremont Avenue. That's nowhere. It's not even around our community. That's on the other side of Saratoga Street somewhere. And so it's not even in direct vicinity of our community. This place of business has been a really bad place of business. We are struggling to keep our community safe, to keep it clean, to retain home ownership. And one of the reasons why we are struggling on that Fremont Avenue corridor, because the Bennett Place is off of Fremont Avenue, the 500 block. The reason why we are struggling is number one, because of that particular business. So we do not want the car title tag, anything to take place in our community. We're asking that you will help us to keep our community safe by denying that petition. And we have community members that have written a lot of letters to your department stating that fact, because we are all familiar with 901 Bennett Place, and it is a nuisance property, which we are hoping one day will be out of the community. It is really a nuisance.
Ask you a question. What is the business you understand is operating at 901 Bennett Place?
Well, the business is a store. One of our neighbors went inside the store one day, and somebody came in, and it was another person, another male that was in the store. Another male came in the store and shot and killed the person right inside that store. That store is not a good place to be, and we really had to get them to cut the ask the city to have them to cut the hours, because one time they were 24/7 open all the time. And so it's not really a good business for the community. He has not done anything to help the community. He has done more harm than hurt.
Do you understand? Do you understand this is for a separate business, not the store? This is not about the store that's there. This is for an office that's going to handle paperwork.
Right. It is, but it's also about the integrity of the person that's running this. And they have said so many things that were not true, and has lost the support of the community by their actions and by their inactions and by all of the bad things that have gone on at that particular store.
Okay. Thank you.
Mm-hmm. Thank you.
Anyone else, please put in the chat if you wish to testify in opposition or raise your hand. I'll go through the call-in users one more time for people in opposition. If you're here to testify in opposition, after you hear two beeps, please speak up. If not, I'll move to the next caller. Okay, next caller. All right, next caller. Next caller. Next caller. Next caller. And last caller. Let me go to the chat. Lisa Mayo. So Miss Mayo, I'm gonna unmute you. Once I get to you, there we go. Okay, Miss Mayo?
Yes. Hi, my name is Lisa Mayo, and I live at Heritage Crossing. I'm also on the board. This is the same man who operated the store, correct?
No.
We don't
No?
know that, ma'am.
Okay, because I could have sworn he said that he used to operate the store as well.
Let's clarify this. Mr. Ogona, who operates the store adjacent to the 901 Bennett Place?
The store is operated by someone else entirely. I've got nothing to do with the store.
Have you ever had anything to do with the store?
The store belongs to Mr. Tony Akpala, and I don't own the store. I don't operate the store.
You have no affiliation business-wise with the store?
No, sir.
Also, when he tried to establish this tag and title place last year, there were cars parked there, and he said that there wasn't, and they had no license plates, and it was taking up space from the residents that live in the area. And I'm afraid that
when have you last seen cars parked there in that manner?
I haven't seen any since we disagreed and we protested.
Okay.
But I'm afraid that him getting people to speak for our community and people lying, saying that they live at a certain address, that they are part of our community, speaks to his character as to him not bringing cars in our community to further his business. And we just don't need that. We've done a lot of upgrading to this community, and that whole business is an eyesore to our community.
He's testified today that that's not the business he was seeking previously, is not the business he's looking to do now. It's a different business. It's a paper office.
Yeah, I don't trust that he would just do tag and title without bringing cars there.
Okay. All right. Anything additional?
No.
Okay, thank you.
Let's see, we received another thing in the chat that the applicant stated that his cousin owned the store or basically stated in 2020 that the store owner was his cousin. So that is all I have. If anybody else wishes to testify in opposition, again, please put something in the chat or raise your hand. I don't see anyone else. And we've gone through the call-in users. So I believe that's it for opposition.
All right. Then we're back to Mr. Oguna. You have the final word. The store, sir, does your cousin own the store?
No, not my. But the person that owns the store I'm originally from.
Stop. We can't hear you.
Can you hear me now?
All right, hold on one
Hello?
second, Mr. Ogana. Apparently there are people on the call. So that are here to testify in opposition, and they say they're not hearing two beeps. So this is what I'm gonna do. I'm gonna say unmute, and if you are here to testify in opposition, say something, and hopefully I'll be able to hear you, okay? So everybody, as we go through it, the first call-in user, I'm gonna unmute. If you're here to testify in opposition, please speak up. All right, you are unmuted, speak up. All right, we're gonna go to the next one. All right, I'm gonna go to the next one. I've just unmuted you. If you're here in opposition, please speak up. All right, we're gonna try this again to the next one. All right, I just unmuted this caller. If you're here in opposition, please speak up. Hello? All right, we're gonna go to the next one. If you're here in opposition, please speak up. Go ahead and say something. All right, we've got 3 more. Next one. You're unmuted, please speak up.
Hello?
Yes. Are you here in opposition?
Yes, I am.
Okay,
Okay.
what's your name, ma'am?
Hi, my name is Lisa Cotton,
Okay, go ahead, Ms.
and I live here in Heritage Crossing, and I oppose what he's trying to do to the community. I do know that it will bring in more cars to our community. More people will be coming in. A lot of things have been happening up there on Fremont Avenue. A lot of shooting, a lot of incidents have been happening up there. And that's been going on for years. And that store up there is definitely an eyesore. And to use it as commercial anything would, I think it would just bring in more problems to our area. If anything, we should, be able to have something better than that up there besides a commercial business. Something else added to bring more to our community and not something that will bring it down. So, yes, I do oppose of it.
Thank you.
Thank you.
All right, so we have 2 more. I'm gonna do the same thing. So if you're in opposition and you haven't already spoken, please speak up. Hello? All right, last one. Well, actually, the one more just popped up. Hold on. If you're here in opposition, please speak up. One more. If you're here in opposition, please speak up.
Can you hear me?
Yes.
This is Wanda Abel, A-B-E-L. I am really opposed to it because
Hold on, Ms.
we have a
Abel.
good neighbor. I'm sorry, say that again, please.
Okay, you can go. Previously, you had an echo.
You want to hear my name again?
No. We hear a significant echo, but go ahead.
Oh, okay. I'm sorry. Okay. Is everything okay now?
Absolutely. Thank you so much.
I'm sorry. My apologies. I'm opposing this because I've been living here close to 20 years. This is a decent neighborhood. Over in that area, we have a citizen on patrol that we walks around. And over in that area, it's not a good area for any business, let alone this new one that's coming up. There's just enough room for the area. I know he said it's not going to have anything to do with cars parking, but everyone knows anything dealing with a car dealership, tags, title, is going to line up with cars. Our area is a decent area. We have our citizens on patrol. This is going to take it down. And this is the reason why I'm opposed to it. That area over there is not a good area for any business. And that's my opinion. And that's it. Thank you very much for the minute that you gave me.
Ms. Abel, what do you suggest should be done with the area?
Really? Well, don't want to speak ill of the dead, but it really don't need it. It need to just build up more nice places for people to live. To me, this is not what you call, say, per business area.
Okay, but there's a
There
store
need to
right
be
next
more
to it.
houses built here for people, sir.
Okay. All right, very well.
All right, then.
Thank you.
Thank you very much. All right.
Okay, so now I think we're done. Opposition testimony.
All right, Mr. Okuna, you have the last word. Anything else you'd like to add?
Yes, sir. I want to say a very big thank you for this opportunity, and I want to appreciate every person that called in. It shows that every one of them, they're concerned about the neighborhood and they want the progress of the neighborhood. But like I earlier stated, my word is my bond. I'm a member of the Army National Guard. I've been with them for over 2 years. I'm a specialist. What I intend to do right here is not a car dealership to park cars all over the road. It's just an office. I think majority of people misinterpret the purpose. You know, there won't be cars parked outside with untagged cars parked outside because the cops is going to tow those cars. You know, I'm just going to do an office with paperwork and all that. Like someone earlier said, I did install cameras all over the place. The place is secure. The neighborhood is okay. And someone earlier said that the area is not good for business, meaning it's just a personal intuition, you know. Maybe probably would prefer they destroy all the buildings in the area. That's not how they build a neighborhood, you know. Like I said, my only usage of the place is for an office. I'm not parking cars all around the place, just for office purpose, paperwork, and that's it. I want to say a very big thank you once more, and I appreciate the time.
Thank you, sir. Appreciate your presentation. All right, that concludes the docket. We'll turn our attention to the deliberation portion of the today's hearing.